We are going to start. So welcome to this ICFML event at Singapore Convention Week, East meets West, a legal and mediation dialogue between Portuguese-speaking countries and Singapore. I am Ana Maria Maia Gonçalves, the founder of ICFML, and it's a pleasure to have you all here. Our event will begin with the welcome message from the ambassadors of Brazil and Portugal in Singapore, and followed by three insightful panels. The first panel will explore the institutionalization of mediation in legal and government systems. The second will delve into the legal frameworks of mediation in Lusophone countries and Singapore. And finally, the third panel will showcase best practice in mediation, insights from the field in Singapore, Brazil, and Portugal. This is a multilingual event, allowing you to choose between English and Portuguese. In the chat Zoom, you will find instructions on how to select your preferred language. If no action is taken, you will hear the speaker in the language they are using in this main room. Additionally, the chat Zoom will provide a link with detailed information about our speakers and moderators. You can also ask any technical question related to the translation function in the chat Zoom to the person named ICFML support. Thank you very much, Julia, for being behind this name. Without further ado, let me introduce ICFML to you with this video of 3 minutes.
On the international stage, ICFML presents itself as a visionary institute, a collective of passionate minds dedicated to turning conflicts into opportunities. We are more than certifiers, we are architects of transformation, creating a global culture of conflict resolution. Our certification goes beyond recognition, it is an adherence to a community of conflict resolution professionals committed to promoting and consolidating high standards of mediation quality, building bridges between Lusophone countries, and creating a unique synergy to embrace the future. ICFML unites mediators, lawyers, academics, and companies in a global alliance. In Portugal, ICFML is accredited as a certifying entity by the Ministry of Justice of Portugal and is the first training entity for business recovery mediators in the country. On an international level, we are partners with the International Mediation Institute, being the only qualifying accessing program of this institution for the Lusophone world. Additionally, we are recognized by CIAP for the ICFML Mediation. We are also founders of the Alliance for Mediation Standards, which grants equivalence to the ICFML certification, conducted in Portuguese, in various Francophone countries, Singapore, China, and Malaysia. Each professional certified by ICFML is an agent of change, challenging paradigms and standing out in the mediation landscape. The ICFML seal is not just a badge, it is a guarantee of excellence and assurance that these professionals are committed to innovation and ethical practice. For companies, mediation is not just a solution, it is a competitive strategic advantage. At ICFML, we empower organizations to navigate conflicts with transparency, fostering lasting and sustainable relationships. Mediation is the new paradigm for the success of companies certified by ICFML, who lead this movement. ICFML certified lawyers are pioneers in mediation advocacy. They transcend the courts, becoming artisans of peace. The certification is not just a credential, it is a guarantee that they are equipped not only to litigate but to guide their clients in seeking innovative and sustainable solutions. Our academic community is a driving force of knowledge. We are breaking new ground in mediation research. Every academic certified by ICFML is a pioneer, guiding the next generation towards a deeper and transformative understanding of conflict resolution. For all involved, governments, businesses, organizations, NGOs, communities, ICFML is a catalyst for positive change. Ready to support projects that transcend borders and build bridges towards a culture of peace and justice. Our commitment is to be the force driving a better and more collaborative world.
Thank you very much. I would also like to take this opportunity to warmly welcome all the members of the ICFML community who are present here today, representing Portuguese-speaking countries around the world. And a special greeting out to the ICFML Brazilian community who are gathering today for the 7th Encontro ICFML in the beautiful city of Rio de Janeiro. I promise to be with you next year, and I wish that today's 7th Encontro will once again be one of those meetings where we feel connected and we recognize the importance of coming together in the professionalization of mediation. But let's move on to the welcome message. I'm honored to introduce Ambassador Eugenia Bartelmes, who has been representing Brazil in Singapore since 2020. Ambassador Bartelmes, thank you for being with us today, and the floor is yours.
Thank you so much. Are we on?
Yes.
Thank you so much, Ana Maria. It's just a very brief word to say how flattered I am, what a pleasure it is to be here this afternoon. So I start by saying good evening to His Excellency Ambassador Carlos Pires, the Ambassador of Portugal to Singapore. A good evening or good morning to all the illustrious participants, depending on the time zone where we all are meeting virtually at this moment. So it is, I'm very thankful to Ana Maria Gonçalves and to the Institute for Certification and Training of Lusophone Mediators for this opportunity to add a few welcome words to the opening of this important East Meets, I love the title, this East Meets West dialogue between the Portuguese-speaking countries and Singapore on the one hand and Singapore on the other hand, in the context of this year's Singapore Convention Week, which is such an important event. So Brazil is, of course, speaking as the Brazilian ambassador in Singapore, Brazil is, of course, a proudly Portuguese-speaking country. And as a country of civil law tradition, of Roman law tradition, from our perspective, Brazil has been accompanying with great interest the manner in which Singapore is consolidating its image as not only a regional platform, but actually a global international center for civil dispute resolution. What we have been witnessing from the Brazilian perspective is the consolidation of Singapore's image as a global center in this context. In this context that is very, very new, the context of new alternative dispute resolution methods, particularly in the case of Singapore through arbitration and through mediation. We all of us, I am a layperson, I am not a specialist, but it's very remarkable, even to the layperson like myself, the manner in which Singapore is outstanding, both in terms of the quality of its judicial process and, as importantly, in terms of the time and cost involved in resolving a commercial dispute, for instance. So what we see, what Brazil sees in Singapore, is this enormous variety of dispute resolution mechanisms which are available under Singaporean law and in the different local Singaporean courts and specific specialized institutions. Be it in arbitration, in commercial litigation, in mediation, in adjudication. What Brazil sees in Singapore is this, again, not just regional, but global center that is consolidating an image as a very innovative center for such alternative new solutions which are out there. So Brazil is, of course, a party to the Singapore Convention on Mediation. And what we feel is getting to the end of my brief message, regardless of juridical tradition, common law, Roman law, we see that the dialogue with Singapore, between Singapore and us Portuguese-speaking countries with our own proud juridical tradition, this is an opportunity for reciprocal learning in the case of Brazil. It is the exchange of views is so welcome in the pursuit of so that we can all achieve faster, more agile, more consensual solutions in the field of dispute resolution. So as I close these brief words, again, with many, many thanks to Ana Maria Gonçalves for the opportunity to take part. Brazil believes, and the Brazilian embassy in Singapore is convinced that this East meets West dialogue, this is going to be a very fruitful exercise, both for Singapore and for the Portuguese-speaking countries. Thank you very much indeed.
Thank you so much, Ambassador Barthelmess, for your insightful and encouraging words. We need that in mediation. And really, I truly appreciate your presence and your support here. And thank you very much for having the time to come on these days that I know that are really, really full of things to organize for you. Thank you very much. And it is also an honor for us to have a representative from Portugal with us. I am delighted to introduce Ambassador Carlos Pires. I hope to meet you, Ambassador, one day here in Singapore for a coffee. And Ambassador Carlos Pires has recently taken up his role as Portugal ambassador to Singapore, now in August 2024. He brings a wealth of experience from his distinguished career in diplomacy and public service. Ambassador Pires, we are honored to have you with us today, and the floor is yours.
Well, thank you so much, Mrs. Ana Maria Gonçalves. It will be a real pleasure to meet you very soon here in Singapore. And I would like to start by thanking the Singapore Ministry of Law and the Institute for Certification and Training of Lusophone Mediators, in particular you, Ana Maria, for your very kind invitation to the 2024 Singapore Convention Week, which I understand is an unprecedented event. It's a premiere. So congratulations for that. And also being my first week in Singapore as ambassador of Portugal, as you have mentioned, it's an honor and a true pleasure to address together with Ambassador Eugenia Barthelmess such a prestigious audience stretching from Brazil to Singapore through Portugal, encompassing so many time zones, as Ambassador Eugenia has mentioned. So while we are ending the afternoon here in Singapore, Brazil and Portugal are still waking up. So bon dia and good afternoon to all distinguished participants. And I'd also like to commend the organizers on the choice, indeed, of the title of this conference, as Ambassador Eugenia has also underlined. Indeed, East meet West. Where else better than in Singapore to bring together this beautiful country, Portugal, Brazil, and our other brothers from Portuguese-speaking countries. We all share in common the fact that we are maritime nations with long histories and cultures and traditions, and which are firm believers in a rule-based multilateral order grounded in a common set of norms to regulate our interactions as nations and as peoples. So the objectives of today's conference couldn't be more aligned with those principles. And I'm therefore very pleased to see so many experts, practitioners, and policymakers sharing their knowledge on dispute resolution, arbitration, and mediation. As Ambassador Eugenia has so rightly pointed out, Singapore's experience in resolving dispute and settling peacefully conflicts in innovative ways for so long is indeed a source of inspiration for us in the Portuguese-speaking community. And I'm sure that also our experience will also be beneficial for our Singaporean partners and friends. So I think this mutual enriching process will be profitable and will bring added value for all. And I'm sure that this event, therefore, will be followed up with concrete recommendations and concrete, I would say, follow-up so that we can meet again and continue sharing our experiences. More broadly, speaking as Ambassador of Portugal in Singapore, and I believe that Ambassador Eugenia Batermes also shares the same view. I strongly believe that the ties between our countries can be even more enriched and deepened, in particular in what concerns this dispute resolution, and by doing so, underpinning and reinforcing the already excellent cooperation at the political, economic, legal, cultural, scientific, and academic levels of among our countries. So in this spirit, I would like to wish all of you a very fruitful and enriching conference ahead, and I'm looking forward to read your conclusions and recommendation and follow up on this session. And I'm really looking forward to meeting you, Ana Maria, very soon. And again, echoing Ambassador Batermes, I would like to commend you on this premiere and give you and wish you all the success and that I'm sure you will deserve and you will attain. Thank you very much for all of you. Muito obrigado.
Muito obrigada. Thank you very much. I say Ambassador Carlos Pires, Ambassador Eugenia Batermes. I can say it's the first time I invite ambassadors to an ICFML event. So thank you very much. It's an honor for us to have you here and for the message of hope that you give us and the hope for mediation to be mainstream in these countries, and also for our Portuguese-speaking countries to learn from Singapore, that is really a center of dispute resolution methods, to how to improve them in the Portuguese-speaking countries and how to learn from them. So this is all about this, what we are going to see during these next hours in this event. And so we will now start the panel 1. Thank you very much again, ambassadors. And the panel
Thank
1
you so much, Maria.
moderated. Thank you. Thank you, Eugenia. Thank you very much.
Thank you so much again for having me. It was, it's really a privilege. I'm very thankful. Thank you so much.
Thank you, Eugenia.
Muito obrigado.
Obrigada. And we will now begin with panel 1. The panel 1 will be moderated by Katia Marques-Boller, who has served as president of ICFML for the past 2 years. Katia is distinguished academic and international researcher, and we are honored to have her lead this important discussion today. Thank you, Katia, and it's over to you.
Thank you, Anna. Thank you all that participating in this excellent event. First of all, allow me to say a few words to the person that organized all these conference, and it is Ana Maria Maia Gonçalves, that is working to promote mediation through the years, and she still have the energy and the ideas to believe in mediation and to promote mediation, especially in the Portuguese-speak country. But also allow me to say a few words to Maria, that is a person in the ICFML that works and that put the ideas of Ana Maria in place. So thank you, Anna, and thank you, Maria, for all the logistic organization of this event. And thank you to all the participants of this first panel one, that we will analyze or speak about the institutionalization of mediation in legal and government systems, because despite of the believers in mediation, we need the legal powers and the departments that are responsible for the development of the alternative dispute resolution to put in place mediation. So thank you all, first of all. We make a few changes in the speakers. So first of all, we will listen the English speakers, and then we listen the Portuguese speakers. So who wants to listen in English, please follow the instructions regarding the translation. We will have simultaneous translation, so follow the instructions that we're sending to you. So first of all, we will listen Yasmin Shin Sabado, that is director of the International Advisory Group Policy Advisor Division of the Ministry of Law of Singapore. Thank you so much, Yasmin, for being here with us, speaking how Singapore is implementing and put in place some policies regarding mediation. The floor is yours, Yasmin. Thank you so much.
Yes, hi. Can you hear me?
Yes, we are listening to you.
Good morning, good afternoon, and good evening to everyone joining us from all over the world. And thank you, ambassadors, for the kind words before I begin any further. Can I just check if the audience can see the deck that we intend to present?
We are seeing your presentation, yes, not in full screen, but we are seeing. Now we are seeing it in full screen. Thank you so much.
Thank you very much. So my name is Jasmine. I'm from the Policy Advisory Division of the Singapore Ministry of Law, MINLAW for short. And in MINLAW, in partnership with various organizations, we are hosting the Singapore Convention Week, which this event is part of. And it gives me a great pleasure to be part of this distinguished panel. The next slide, please. So I have been asked to share about what Singapore is doing for mediation at the institutional level and how mediation has been implemented across various legal and government systems in Singapore. And to do that, I'll be just sharing briefly in two things: the timeline of mediation in Singapore and the Singapore model, and that is our thinking and philosophy to mediation. Next slide. So first of all, our development. Now, what you see here is essentially a visual snapshot of how mediation developed in Singapore. So you see here what it started off as court-led or court-annexed mediation, and it slowly expanded to mediation in communities in Singapore, and then finally, before it reaches the international level. The next slide. This is a little bit of a busy slide, but you can see this is our journey, our mediation journey. So mediation is not foreign to our local culture, and is embedded in the practices of many of the ethnic groups in Singapore. The term mediation may perhaps be new, but the concept is not something that is new for us. And here you see some of the key milestones related to mediation in Singapore. On an institutional level, mediation was introduced in 1994. This is what we call, what I mentioned earlier as the court annexed mediation. It was introduced then. In 1996, we had the Cross-Sector Committee on Alternative Dispute Resolution. This was formed to look at how alternative processes could be promoted beyond the courts. This resulted in a national framework to promote ADR in a measured and phased manner. And the focus in these early years was really on domestic, civil, and social mediation needs, while laying the foundation for future commercial mediation. You'll see next in 1997, the Singapore Mediation Center was established. And in 1998, a network of easily accessible community mediation centers was established as a grassroots-led initiative, where basically communities were called upon to resolve disputes through mediation. So from the late 1990s to the 2000s, you see a rise in cross-border commercial activities and transactions, and parties needed a fair, efficient, and transparent way to resolve cross-border disputes. So in 2013, a working group was formed to explore ways to develop Singapore as a center for international commercial mediation. The recommendations of this working group were implemented over the years, which included the establishment of the Singapore International Mediation Center in 2014, as well as the enactment of the Mediation Act in 2017. And of course, in 2019, that is the milestone for Singapore, and it was when Singapore signed the Singapore Convention on Mediation and hosted the signing ceremony. So I'll elaborate a bit more on that later. I would like to talk a bit more now about the Singapore model. Now, for us in Singapore, we consider that it is necessary to have in place an ecosystem to have a successful mediation system. And this is not just for mediation, but we also have that for arbitration and for litigation. And the changes that we therefore have introduced and put in place is essentially to these various aspects or parts of our ecosystem, whether it be the legal framework, the institution, the thought leadership, or the industry. So I will share very briefly on each of these areas. This is our a snapshot of our legal framework in Singapore on mediation. So first of all, we have an open regime. So the parties here are free to engage lawyers and mediators of any nationality, and they can use any governing law. And of course, with this, I'm addressing commercial mediation, right, where we have parties that are sophisticated. We also have in place supportive legislation. I will elaborate a bit more on this later. And the legislation is really intended to provide backing of the law as well as clarity to the mediation regime. Third, parties, and this is a very important piece in our view, parties have to be assured that mediation can be enforced. Now, the lawyers among us, we know that if you have a settlement agreement, essentially you have a contract that is enforceable. But with mediation in place, what we have with our legislation to ensure that this agreement will have the force of law. You can enforce it like you can enforce an arbitration award or a judgment. We also have professional bodies that we introduced, which is the Singapore International Mediation Institute, to set standards and accredit mediators to ensure that we have good mediators in place to ensure a certain standard, right? And the Singapore judiciary lends a strong support to greater use of what we consider appropriate dispute resolution. And I shared earlier about how in the beginning, it was very much court-led mediation. Judges referred cases that were in litigation to mediation to be heard. And that has been quite critical in shaping our environment. I would just also mention that in January 2023, the Singapore International Commercial Court and the Singapore International Mediation Center collaborated to establish a litigation framework. Essentially, this means that when a party goes to litigation, they can pause litigation and refer the matter to mediation. And thereafter, you can have that award enforced, the mediation settlement agreement enforced, or if you wish, you can refer the same matter back to the courts again, where it gets recorded as a consent order. So what we have in place is really a system where parties can choose what works best for them. And last but not least, we have an open regime where we have all foreigners providing mediation services, such as mediators. They can provide their services here without a work pass. So this helps to minimize, of course, administrative demands. I want to move on a little bit to what I mentioned earlier about the legislation that we have in place. And here I will talk about three pieces. The first piece being the Community Mediation Centers Act. And essentially, this act was introduced to operationalize our initiatives. It provided for the establishment and operation of the centers that I mentioned earlier, so that community disputes can be resolved through mediation. So to provide some context on the work that the CMC does, from 1998 to 2023, the CMCs have handled more than 11,000 community disputes, with a very successful rate of about 80% for these voluntary mediation cases. We also introduced a Community Disputes Management Framework in 2014 to further facilitate effective resolution of neighbor disputes and to foster a more harmonious living environment for Singaporeans. The next slide, please. So I had addressed earlier what we consider community disputes. And now you see with the progression of time, our framework becomes more sophisticated. So with this, even with community mediation, we have introduced further measures, or will be introducing further measures to strengthen the framework. Next slide, please. Moving on to commercial or international commercial mediation. So apart from what I shared earlier, we have two main pieces of legislation in place. The first one being the Mediation Act 2017, and it was enacted to strengthen our framework to support mediation. It facilitates the enforcement of mediated settlement agreements conducted in Singapore by allowing parties to record them as in court order. It also codifies certain issues previously dealt with under common law, which is matters like confidentiality. The Singapore Convention on Mediation Act was enacted subsequently in 2020 to implement our obligation under the Singapore Convention on Mediation. The next slide. Essentially, this is a very, very quick comparison of the differences between the two acts. The Mediation Act has a different focus where from the Singapore Convention on Mediation Act, one requires a nexus of Singapore, the other does not. One requires that the mediation services be administered by designated mediation service providers, whereas the other one does not have such a requirement. The next slide, please. So the Singapore Convention on Mediation, we consider it a very important piece in our dispute resolution framework. The often cited obstacles in mediation I had mentioned earlier, which essentially there's lack of a framework to enforce a mediated settlement agreement. Parties don't want just a contract. So with the SCM in place, this is an added assurance to parties that like an arbitral award, like a court judgment, their mediated settlement agreements can also be equally enforced. So the SCM, the Singapore Convention on Mediation, therefore, is the missing third piece in this global framework for dispute resolution for the enforcement of awards and agreements. And it really joins its place among the other two conventions that we've seen on the screen. There has been strong support from countries for the SCM. When it opened for signature in 2019, it had the highest number of first-day signatories for United Nations Trade Convention. It entered into force on 12 September 2020, only a year after it was opened for signature. And today we have several parties and signatories to the SCM. And this includes countries like Brazil, Guinea-Bissau, and Timor-Leste, who have signed the SCM. So, of course, the more countries we have on board, the more effective the SCM will be, because mediated settlement agreements can then be enforced easily in more countries. And this will be definitely conducive to trade. I would also highlight that the SCM caters to both common law and civil law jurisdictions, and the countries that have ratified the SCM includes countries from both types of jurisdictions. So we're very hopeful that more countries will come on board as parties. Moving on, just to share how we have done this in Singapore, I had mentioned earlier our timeline for mediation, and this really is a focus now on the timeline for international commercial mediation. You'll see that on the 4th of February, we enacted the Singapore Convention on Mediation Act, and then we deposited the instrument of ratification in February in 2020 as well. And on 12 September 2020, the convention entered into force. And at the same time, our SCM Act and the Supreme Court mediation rules also came into force. So the SCM Act sets out the main framework, and the rules basically is your rules of court, as the other lawyers amongst us will know. So in designing the legislation, we had in mind that the convention left parties, you can decide your own rules basically to effect the convention in your countries. For Singapore, how we did it is we worked very closely together with the various stakeholders to design a framework for mediation that is usable. And who are our stakeholders? Our judiciary. The High Court is designated as the competent authority under our SCM Act. We worked very closely with our mediation and arbitration institutions, and of course, with the legal experts and practitioners. Why do we do this? Because we consider that it is important that when the Act is actually rolled out, it has to be a practical one that can be operationalized. In designing our SCM Act, we had in mind that the Act has to be flexible. So parties, again, can opt for what they want, whether they want to choose relief under the Mediation Act or the SCM Act. If you don't want it to be enforced as an order of court, you can also enforce it as a contract. The usual principles remain in place. For the users in Singapore, we had in mind that those who are already familiar with the Mediation Act and the International Arbitration Act, we introduced our SCM Act in a way that the tools and the processes are similar so that it will be familiar to them, it won't add to any confusion. Earlier, I had mentioned that in Singapore, we consider it important to have an effective mediation system. There must be an ecosystem in place. So these are some of the ecosystems, the considerations that we have. The mediation providers, the bodies that set in place standards, thought leadership, as well as infrastructure. I'll talk about each of them very, very quickly. I had mentioned earlier the SMC, Singapore Mediation Center. And these are some brief statistics. The SMC primarily focuses on domestic and court-annexed mediation, and the sitting judge of the Supreme Court of Singapore serves as SMC's chairperson. So the SMC's successful settlement rates has helped us to save court resources, enabled the courts to deliver justice quickly and efficiently. Moving on to the SIMC, the focus here really is on best of the class international commercial mediation. So the SIMC focuses on the development of international commercial mediation in Singapore, and to ensure a world-class service, they have an international board of directors, a panel of over 74 highly qualified international mediators from 14 countries, and a panel of more than 70 technical experts and specialists. I want to talk a bit more about other service providers that we have. Here are just some examples. If you can see, for example, in the top left, we have mediation institutions that are focused on healthcare, so they can resolve disputes relating perhaps to unhappiness over service quality, patient care, and medical management. We also have what we call the Tripartite Alliance for Dispute Management on your right side. And the focus, this is a cooperation between the Singapore Ministry of Manpower, National Trade Union Congress, and the Singapore National Employers Federation. And through advisory and mediation services, they help employees and employers manage employment disputes. Next slide. Here we have SIMI, or moving on, yes, next slide. So SIMI is really set up as a professional self-regulatory body, and it certifies the competency of mediators through its credentialing schemes. Next slide. Thought leadership. So what we have set up in Singapore as well is the Singapore International Dispute Resolution Academy. So it's a research institution seated in one of our universities, and they they serve as a platform for thought leadership in international dispute resolution theory, on practice and policy. Again, I pause here to mention that it's an ecosystem approach. So it's not just having the laws in place, but we also need the institutions as well as the universities on board to continue to advocate the message of mediation. Next on, we have the infrastructure. And by this, I mean An example of which would be our Maxwell Chambers, established in 2010. Maxwell Chambers is the world's first integrated dispute resolution complex with best-in-class hearing facilities, and the venue includes rooms purpose-built for mediation sessions. Next slide. Again, part of our ecosystem, we have many law practices that also have a mediation practice. So to support the need, that's not just for community or domestic mediation, but also for international commercial mediation. Next slide. So in Singapore, we're committed to building the international dispute resolution space. Having reaped the benefits of mediation, we're very happy to share this experience with others. And you have seen some of this. So in the context of perhaps the Aung San Suu Kyi Academy, which MinLaw co-organizes with Aung San Suu Kyi, and that is part of the Singapore Convention Week as well. So Singapore has been invited to various countries to share our views and our experience on mediation with other governmental colleagues. Here you see photos of some of our recent visits to Kuala Lumpur as well as to Seoul, where we shared our experience in implementing the Singapore Convention on Mediation domestically, as well as some of our journey in mediation. So in Singapore, we really stand ready to share our experience, what we've learned, exchange views as well to any of the governmental colleagues that may be interested on mediation as well. And with that, I come to the end of my sharing. I hope I have offered some insight into the development of mediation in Singapore over the years and how mediation continues to be implemented across our various legal and administrative systems. I look forward to the sharing by the other distinguished speakers as well. Thank you.
Thank you so much, Director Yasmin, for the excellent presentation about the Singapore system, because it's an integrated system that is not only in law, but it is complemented with some measures and policies regarding the implementation in courts and also in the communities. So it's quite interesting, and your willingness to share your experience and learn with our experience also, and this the main goal of this panel. So thank you so much for your presentation. And now I will give floor to District Judge Yarni Loy, that I think it is already with us. District Judge Yarni Loy is a Singapore representative of the family mediation in Singapore courts, and as we saw in the previously presentation, the family mediation is quite important also in Singapore. So thank you so much for have accepted our invitation for being here, and the floor is yours.
All right. A very good evening to everyone. Can you hear me?
Yes, we can hear, and we already are seeing your presentation, not in full screen, but we are seeing.
I'm trying to make it full screen.
You can in the yes. I think it's easier in the buttons in the near to the yes, no, to the left, the next one, the next one before the plus, no, to yeah, no, yes, this one.
All right. Okay, thank you so much.
Thank you so much.
All right, a very good evening to everyone. Today I'll share a slice of the FJC story. FJC would be the Family Justice Courts. Specifically, I will share about the adoption of ADR for the resolution of matrimonial disputes. Okay, I'll share this story in 3 chapters. In the first chapter, I will share how we first introduced ADR into the family justice system, and how it really was initially introduced as an alternative dispute resolution mechanism, and it evolved and became recognized as being a more appropriate method of dispute resolution for matrimonial disputes. I will then share how, with the establishment of the Family Justice Courts as a separate unified court in 2014, ADR really evolved to become the mainstay and the mainstream of matrimonial dispute resolution. And then I'll touch very briefly on how we are moving towards a vision of what we call therapeutic justice for the entire court process for matrimonial disputes. Very quickly, when parties or families come to the family courts, they are basically asking the court to reorganize and rearrange their most intimate and private family matters, personal, financial, as well as relational, to ask the court to really help them adjust to a new future. And they're basically asking the court to do that at a time when emotions are the most heightened, when there are still lots of unresolved issues involving trauma or grief, betrayal, hurt, and anger, as well as fear. The fear of loss of identity, losing relationships, losing a child worried about losing a parent. And these relationships really continue beyond the legal case. And when children are involved, the parenting relationship has to go on and the children need to be protected. So there are all these extra legal considerations that come into play when we are thinking about how we can better resolve family issues. And I think increasingly around the world, it's been recognized that the adversarial litigation model is not best suited for resolving family matters because it aggravates emotions and generates conflict, which make it so much harder for families to find that peace necessary to move on. It focuses on a winner and a loser when there are really no winners or losers in family matters. And it's the families, the children who need to go on, who need to grow up. And as well known, adversarial litigation emphasizes a rights-based approach. It's about finding fault, apportioning blame, when sometimes really nobody's at fault, and it's about finding timely and enduring solutions. So bearing in mind all these extra legal factors, I think family courts all around the world are basically grappling with how better to resolve family matters. And so this is just the Singapore experience. And I'll start the story in 1st of March 1995, when the Family and Juvenile Justice Division was established under the then subordinate courts, now known as the state courts. So I think at that time in the mid-1990s, legislation was also introduced to empower the court to refer parties to mediation with their consent and also to direct suitable cases to counseling. So it was not just mediation, but also the interdisciplinary aspects such as counseling. At that time, mediation was conducted on an ad hoc basis, and we used volunteer mediators. The interpreters were also mediating your court staff and judges, and a small in-house counseling unit was also set up. So at this point, it was really about managing cases to clear the backlog in the courts. It was introduced as an alternative and a more efficient way of resolving disputes. So in the next decade, we continued to build on their strengths, and the Family Resolution Chambers was set up as a dedicated division, consolidating our various mediation programs. In 2007, the Maintenance Mediation Chambers was set up to focus on mediating maintenance cases. And in 2009, our counseling and psychological services were really rebranded as the Counseling and Psychological Service Division, or how we affectionately refer to them as the CAPS Division, which is how we still refer to them today. And the court counselors, psychologists, and social workers in the CAPS Division are known as court family specialists. And all these developments culminated in 2011 with legislation introduced to make mediation and counseling mandatory for divorcing couples with at least one minor child. And the Child Focus Resolution Center was set out to carry out mandatory mediation. I should also point out that in the FJC, it's the judges who carry out mediation as well. So it's judge mediators working very closely with court family specialists to try to really help families resolve their matrimonial issues, their children's issues, etc., to provide the emotional support. And in that way, I guess the families and the parties, they benefit from the legal and judicial expertise of the judge mediator, as well as the social science expertise of the counselors or court family specialists, as we call them. So as you can tell from this very quick review, this is really only a summary. From being introduced as an alternative, a more expedient and less confrontational mode of dispute resolution in a very small way in the mid-1990s, ADR mediation and counseling and the interdisciplinary angle became recognized as being a more appropriate method of dispute resolution for child cases. Which brings me to my next chapter on how, with the establishment of the FJC in 2014, ADR became not just more appropriate, but really the mainstay or mainstream of how we resolve matrimonial disputes. So on 1st October 2014, the Family Justice Act was passed and the Family Justice Court was established as a separate unified family court. So we were no longer just a division within the state courts, but we were a separate court, established as a separate court, to really give us the resources and the space to try to do things differently and move even further away from the traditional adversarial paradigm. So I'll just quote here from what our Chief Justice, Sundaresh Menon, said at the opening of the Family Justice Courts, in 2014, that today we mark a reform effort that has effected and will in the coming months continue to effect fundamental changes to the way we approach and resolve disputes concerning the family. We will no longer function in the traditional adversarial paradigm. Our view of the services that the courts provide and the way they do so must change. The search for alternative models for family justice reflects the realization that subjecting a fractured family to the stress of an adversarial litigation is simply unwise. And specifically on counseling and mediation, he said, it will often, even if not invariably, be the case that counseling and mediation can better address disputes in the context of these relationships and might yet preserve the prospects for the parties to move forward constructively in their ongoing relationships. And he also mentioned that for cases requiring adjudication, the judge will be empowered to give a wide range of directions to better control proceedings. And he likened the judicial task to that of a doctor with a focus on diagnosing the problem, having the appropriate bedside manner to engender trust and convey empathy, and the wisdom to choose the right course of treatment so as to bring a measure of healing. So this is just a snapshot of what's taken place since the establishment of the Family Justice Courts on the 1st of October 2014. So legislation was passed to empower the court to direct parties to mediation and counseling or any counseling program at any time. So this is over and on top of the mandatory mediation and counseling for cases with divorcing parties with minor children. And at the same time, we introduced the judge-led rule for judges to have the power to more proactively manage a case. And importantly, we introduced what we call the simplified uncontested divorce track. So basically, if parties are able to resolve their matters outside amicably, they can basically file court papers and obtain final divorce and ancillary orders rather administratively. So they don't actually have to come down to court. So the idea was to really encourage this culture of mediation, of ADR, for parties to make use of the opportunity to resolve matters outside court without having to actually come to court in person to get the final divorce orders. So in order to build and promote this culture of mediation, we continued to strengthen our ADR practices, and the Family Disputes Resolution Division was set up to bring our mediation and counseling units under one division. At the same time, the Family Justice Courts worked very closely with the Singapore Mediation Centre to put together the Family Mediation Certification Program. So participants who pass this program can be empaneled on the SMC panel for family mediators. And the intent then was to really promote mediation expertise amongst family judges, as well as family practitioners who are interested to practice mediation outside court. So there have been several runs of this program since it was first launched in 2015, and it's, I think, quite highly anticipated. It's specifically designed to teach participants how to mediate family disputes. So over time, the number of cases filed under the simplified uncontested divorce track has increased. And today, I think about 66% of cases are actually filed through the simplified track process. So that leaves a smaller number of cases for the court to have to actively intervene. In addition to the mediation angle, as I mentioned earlier, for us in the FJC, the interdisciplinary angle is also really important, and we have always been focusing on that. And with the establishment of FJC in 2014, we have had very close interactions and dialogues with the Ministry of Family and Social Development on how we can provide more programs in the upstream stage as well as in the downstream stage to help families. After FJC was established, we initially had 4 divorce support agencies, but today we actually have 10 divorce support agencies known as FAM and FSC. So they provide a whole range of services, like I said, from the upstream stage, where they provide mandatory co-parenting program, as well as, in the downstream stage in terms of counseling and children in between programs. So again, if we take a snapshot of what's happened since the establishment of FJC in 2014, we can see that it's evolved even further from being the more appropriate method of dispute resolution to the mainstay of dispute resolution. So basically, it's really become mainstream. And in terms of the statistics, like I mentioned, about 66% of cases are filed through the simplified uncontested divorce track. And within court, in terms of our mediation, it's more than 60% of cases actually that are mediated in court are fully resolved on all their divorce and ancillary issues. So really, that leaves a smaller bucket of cases, the more contentious cases perhaps that the courts need to actively try still to resolve, whether in terms of adjudication, etc. So that is how the evolution has grown since the establishment of the FJC. And I'll now touch very briefly on our future and how we envision a future marked by therapeutic justice, what we call therapeutic justice. So in May 2020, our then presiding judge, Justice Debbie Ong, she spoke about therapeutic justice as being a lens of care for the family justice courts. And she basically stated that FJC is fully committed to therapeutic justice in a problem-solving, multidisciplinary environment. So what is therapeutic justice? I think therapeutic jurisprudence was introduced in the mid-1980s by 2 professors, Wexler and Winnick, in the mental health law arena. And basically, TJ views the law as a social force that may produce therapeutic that is helpful, or anti-therapeutic that is harmful consequences, both intended or unintended, or justice participants. And so what it does is it provides a lens of perspective through which we can examine the effects of law, legal procedures, and court processes, as well as the behavior of legal actors, including judges and lawyers and court staff, on the psychological and emotional well-being of family justice participants. So really, it puts the emotional and psychological well-being of family justice participants at the center stage. And it teaches us to think of law not in terms of black letter law, but as law in action. How does this law actually practically affect the parties who actually have to use the court services? So this concept of therapeutic justice has been endorsed by our Chief Justice as well. And in his keynote address at the 8th Family Law and Children's Rights Conference, or the World Congress in 2021, he basically summarized that TJ engages with the deeper human elements that underlie a dispute, that is, the social, psychological, and emotional aspects. And the Court of Appeal has also endorsed TJ as being not merely an ideal, but a necessity, because when family relationships break down, these relationships are damaged, and healing cannot begin to take place if the parties are in an antagonistic relationship or waging war against each other. So in practical terms, and this is my final slide, I know I have taken up too much time. So this is my final slide, but basically I think with the adoption of therapeutic justice as our lens of care, we are in FJC trying to see how we can further integrate TJ into our family justice system. And apart from introducing certain triage processes, we're also introducing what we call the TJ Cooperative Conference. So this is the first court event that parties and the lawyers have to attend. And the idea is to really set the problem-solving tone at the outset for lawyers and parties, and to tell them that regardless of whether it's mediation or adjudication, we expect everybody to have this problem-solving mindset. It's presided over by a judge mediator, possibly with a court family specialist, who will follow through to mediate the case. And for appropriate cases, it will also be the same hearing judge following through the case under the idea of one family, one team. So we are still starting out this approach in a small way, but these are initiatives basically to see how we can continue to have a different system that better serves the families who actually need the court's assistance. So basically what's happened to me basically is that the principles underpinning mediation and ADR, that is interest-based, problem-solving, forward-looking, those principles are now basically have now evolved and infused the entire court process within the family justice system. So it's not just confined to ADR, but really this method of thinking has now influence the way we shape our court processes, the way our judges manage cases, as well as the way we hope lawyers can also help in terms of the problem-solving aspect of resolving disputes. Bearing in mind that really there's no one winner and it's the whole family that needs to move on. So there's also a lot of focus on training as well, in terms of training judges, lawyers, as well as the social science sector on the philosophy that we have adopted within the FJC. So this is not the end of the story, but this is where we're at now. So I hope it gives you a small glimpse of what the Family Justice Courts has been trying to do in terms of the evolution of ADR principles. All right, I think that's all I have. Thank you so much.
Thank you so much, District Judge Yarne Loy. Essential for bring us the idea of a therapeutical justice. It's true, because I think justice nowadays should be more pedagogical, and having in mind this idea of therapeutic goal, it's quite interesting. So thank you so much for that perspective and for the amazing job that you are doing in Singapore. So now the East will meet the West, and we're going to stop in Portugal, and I will give floor to Lídia Jacó, that is Director General of the Directorate General for Justice Policy of Portugal, that is an entity in the Ministry of Justice in Portugal that is responsible for promoting alternative dispute resolution in general, and especially in or about mediation. So thank you so much, Lídia Jacó, for accepting our invitation, and also for always be so available for this FML and for our events and for our ideas. Thank you so much, and the floor is yours. You have to turn on the sound.
Yes, I have two computers here. Thank you. Sorry for my delay. I have two computers here, and it's not easy to bring them to life. Well, first of all, I'm going to speak in Portuguese. I hope you all don't mind. First, I thank you very much, Katia, for your introduction and to be moderator. And of course, I'm going to begin my speech. I didn't have time to prepare slides. I'm going to speak a little bit about our legislation and our framework in what concerns ADR in Portugal. So, muito bom dia, minhas senhoras e meus senhores. É de facto gosto estar aqui nesta conferência em que o Oeste encontra o Oeste e vice-versa, e por isso eu posso dizer bom dia, boa tarde ou boa noite, conforme o local onde estejam a ouvir-nos e a ver-nos. Antes de mais, congratular não só de forma especial a nossa moderadora, a professora Cátia Cebola, pela dinâmica e pelo entusiasmo sempre colocado nestas conferências e nesta matéria tão relevante para nós todos como cidadãos e para a justiça em especial, e de forma ainda mais especial na pessoa da sua presidente, a senhora professora Ana Maria Maia Gonçalves, por esta interessante iniciativa que de facto Portugal e em concreto o Ministério da Justiça e esta direção-geral da qual eu sou diretora-geral nunca se poderia aliar. E através de vós cumprimento todos os profissionais, os nossos dois embaixadores, se é que eu posso usar o pronome nossos, a senhora embaixadora do Brasil, a senhora embaixadora de Portugal, que cumprimento de forma muito, muito especial e que de facto engrandeceram esta iniciativa com a sua presença. Foi muito interessante ouvir as anteriores intervenções, estamos sempre a aprender e para isto, estas intervenções e estas iniciativas são fundamentais, porque à distância de um clique em que nós todos nos podemos ouvir, embora uns tenham que madrugar, outros já estejam quase a dormir, conseguimos de facto partilhar experiências e ainda que os nossos ordenamentos jurídicos sejam diferentes, nós somos todos seres humanos e todos temos o mesmo objetivo, que é viver melhor, termos paz nas nossas vidas e atingirmos os nossos objetivos de cada vez termos uma vida melhor para os nossos filhos, os nossos netos. Assim, todos os profissionais sintam-se cumprimentados, todos os colegas oradores, não somente na área da mediação, mas em todas as áreas que complementarmente falaram e vão falar. Cabe-me partilhar, por isso, a nossa experiência em matéria de sistemas públicos de mediação, fazendo uso desta perspectiva da nossa Direção-Geral, atento o facto de a Direção-Geral incorporar na nossa estrutura orgânica uma área que é exatamente o Gabinete de Resolução Alternativa de Litígios. Nós temos esta atribuição no governo português, dentro do Ministério da Justiça, somos nós quem certifica as entidades formadoras, como exatamente acontece com a ICFML e outras congêneres, no caso da mediação, e já passo a explicar de forma sucinta, esperando não tomar muito tempo e não ser muito maçadora. Assim, nós temos em todas as áreas da relação alternativa de litígios competências, seja na criação dos julgados de paz, onde também se incluem serviços de mediação, predominantemente em matéria civil. Portanto, os julgados de paz também têm mediação incorporada, seja na gestão dos serviços públicos da mediação especializados na matéria familiar, na matéria laboral e na matéria penal. E ainda, como eu disse anteriormente, perdão, na certificação de entidades nacionais aptas a ministrar cursos de mediação de conflitos e de entidades formadoras de mediadores de recuperação de empresas, sendo o ICFML uma destas entidades muito prestigiadas e com muito gosto aqui estamos. Assim, vou aprofundar alguns destes domínios de atuação, começando por reportar-me ao marco importantíssimo do ponto de vista legislativo, que é uma lei da Assembleia da República, que é a 29/2013, de 19 de abril, conhecida por Lei da Mediação, Mediation Law, que estabelece os princípios gerais aplicáveis à mediação realizada em Portugal, independentemente da natureza pública ou privada da entidade que realiza esta mediação ou da matéria em causa, bem como todos os regimes jurídicos da mediação civil e comercial, também dos mediadores e ainda da mediação pública. Com exceção da mediação penal, o que mais tarde irei falar aqui um pouquinho, este é um instrumento normativo basilar e fundamental para a mediação que é exercida em Portugal. É uma espécie da nossa carta basilar para a mediação. Começando ainda pelos julgados de paz, Peace Courts, que é uma das áreas fundamentais da relação alternativa de litígios, em que, como sabem, enfim, eu vou explicar, em Portugal são considerados verdadeiros tribunais. Estão constitucionalmente consagrados, a nossa Constituição considera os julgados de paz como tribunais, com a mesma soberania e que têm características próprias de funcionamento e organização. De facto, têm alguma competência limitada, apenas a causas de natureza civil e a um certo valor, e assentam num histórico que está na lei e que é muito interessante, porque é uma parceria entre duas entidades públicas. É o Ministério da Justiça, através desta Direção-Geral, e os municípios, as chamadas câmaras municipais em Portugal, ou autarquias, ou então também com entidades públicas de reconhecido mérito. E o financiamento é partilhado entre estas entidades. Nós subvencionamos os vencimentos, o pagamento da remuneração dos juízes de paz e outras despesas, as câmaras municipais têm as instalações por sua conta e, portanto, as despesas e alguns funcionários administrativos e as despesas vão sendo repartidas desta forma. É, de facto, um exemplo de uma parceria entre o poder central e o poder local muitíssimo interessante e que alguns países também têm vindo a consultar e verificar com sucesso. Compete-nos, por isso, prestar apoio à criação e desenvolvimento destes julgados de paz, onde se inclui o apoio e acompanhamento à avaliação de desenvolvimento no âmbito da recolha, tratamento e divulgação de informação estatística e ainda o aperfeiçoamento dos sistemas informáticos destes julgados de paz. Esta atuação dos julgados de paz é vocacionada para permitir a participação cívica dos interessados, para estimular a justa composição dos litígios por acordo das partes, daí que estes tribunais tenham uma peculiaridade muito importante, ou seja, aqui uma especialidade que cumpre aqui salientar, e principalmente nesta conferência sobre mediação, que é de facto aqui o mainstream que nós temos aqui todos como linha que nos une, é que nestes tribunais nós temos uma resposta de mediação. Portanto, nós temos dentro dos julgados de paz a mediação integrando uma fase eventual deste processo. Assim, quando tem lugar uma fase integrante de um processo em que o julgado de paz está a ser chamado, em que as partes interpuseram a ação no julgado de paz, a mediação é desenvolvida e limitada à área civil. Porém, os julgados de paz também disponibilizam ainda outro serviço. Temos a mediação dentro dos próprios processos, que é uma fase de pré-mediação, em que, se as partes conseguirem chegar a acordo nessa fase de pré-mediação, já não necessitam de ir para a audiência de julgamento, e esse é que é o grande objetivo, é alcançar a paz, alcançar o acordo entre as partes. Se, todavia, isso não for possível, obviamente, segue para julgamento. Mas, além disso, existe também um serviço de mediação em que nós utilizamos os edifícios, utilizamos os julgados de paz para podermos também fazer extra competência, uma mediação, ainda que não haja um processo interposto no julgado de paz. Portanto, o próprio julgado de paz, o edifício em si, alberga também os serviços de mediação, com exceção dos conflitos que tenham na base a prática de um crime. Não abrange a matéria penal. Nós temos 97 mediadores, 97 mediators, que exercem atividade nos julgados de paz e que mantêm com o Ministério da Justiça uma relação de prestação de serviço muito profícua, sendo recrutados na sequência de concurso público. Há uma série de requisitos e é a Direção-Geral da Política de Justiça e eu, como Diretora-Geral, que no fim imito o despacho de designação e notifico esses mediadores que se propuseram a integrar essas listas. Assim, nós somos responsáveis por 3 áreas de mediação fundamentais em matéria especializada: mediação familiar, é um sistema público, o sistema de mediação laboral e o sistema de mediação penal. O sistema de mediação familiar foi criado formalmente em 2007, através de um despacho normativo que a Secretária de Estado da Justiça proferiu e que abrange todo o território português. É de norte a sul ilhas. Portanto, temos um sistema de mediação familiar totalmente abrangente no território nacional e que tem competência para dirimir qualquer conflito, neste caso mediar, surgido no âmbito das relações familiares e abrangendo também conflitos relacionados com responsabilidades parentais, divórcio, entre outros que possamos referir, desde que envolvam pessoas ligadas por um vínculo familiar. Portanto, esta é a condição sine qua non inicial, é que haja aqui algum vínculo familiar. Temos 87 listas de mediação geograficamente referenciadas, integradas, neste caso, por 152, refiro, mediadores com formação especializada em matéria familiar. Isto pode parecer de sumenos, mas para um país da nossa dimensão é de facto um número bastante razoável, diria mesmo bom. É ainda muito desconhecido. Nós temos feito um grande trabalho, estou aqui a puxar um bocadinho também ao trabalho que nós temos feito aqui na Direção-Geral, mas também com a colaboração de todas as entidades, na comunicação, que é fundamental haver esta comunicação, para que as pessoas, os cidadãos, conheçam este serviço de mediação, porque muitas vezes só não recorrem a eles porque não conhecem suficientemente bem. E aqui a mediação funciona tanto localmente, presencialmente, como também através de videoconferência, caso as pessoas assim o prefiram. Portanto, tem que haver um acordo para que haja uma mediação por videoconferência. Poderá não ser igual do que aquela que é presencial, mas isso é uma opção das pessoas, até podem fazer uma por videoconferência e outra presencial, por exemplo. É um serviço com baixo custo, no fundo é um serviço público, em muitos casos isento até de custos, como é o caso no caso da mediação familiar, tem um custo de 50 euros para cada uma das partes, que é algo irrisório comparado com outros serviços públicos e designadamente da Justiça, independentemente do número de sessões de mediação. Todavia, o legislador também consagrou isenções, como seja, por exemplo, no caso em que as partes são remetidos para a mediação por parte de um tribunal judicial. Se há um juiz num tribunal judicial que interrompe, suspende um processo, e pode fazê-lo, na lei portuguesa isso é possível, e nós fomentamos que isso aconteça cada vez mais, em que o juiz de um tribunal de família interrompe, suspende a instância e envia para a mediação esse pedido para que as partes se entendam. As comissões de proteção de menores e jovens também, no âmbito de processos que envolvam crianças e jovens menores, também podem enviar processos para efeitos de mediação familiar, ou então também quando há apoio judiciário aos participantes na mediação. Nestes casos estão isentas de custos, portanto é algo que tem de ser fomentado, tem que ser dito, é aqui um trabalho também de equipa do Ministério da Justiça com todos os players e todos os stakeholders, mas também com os magistrados judiciais, os senhores magistrados do Ministério Público, as próprias associações, as ONGs, as entidades certificadoras na mediação. É um trabalho conjunto, só pode ser feito em equipa, não é? Como alguém dizia, um vai mais depressa, mas todos juntos vamos mais longe, e é isso que nós queremos fazer. Assim, a generalidade dos acordos celebrados em matéria familiar em Portugal depois tem de ser homologado por um juiz ou por conservador do registro civil, isto nestes casos que eu me referi. Temos ainda a mediação laboral, foi criada em 2006 e aqui nestes casos quer o empregador, quer o trabalhador podem recorrer a este serviço, desde que seja dirigida à resolução de um conflito laboral emergente de um contrato individual de trabalho e desde que não contenda, ou seja, que não implique direitos indisponíveis nem acidentes de trabalho. Este procedimento apenas terá lugar quando todos se dispuserem voluntariamente a participar. E nisto é que reside aqui, realmente, o sistema de mediação laboral. Tem que haver aqui um acordo e anuência de todas as partes para este efeito. Este serviço e funcionamento desta mediação é igual, muito similar à mediação familiar. Temos também as listas de mediadores, os custos também é exatamente a mesma coisa como eu referi da mediação familiar. Contudo, aqui neste sistema apenas podem prestar serviço os mediadores com formação especializada na área laboral. Isto porque a legislação laboral é complexa, está sempre em constante alteração, em constante mutação. Há muitas alterações legislativas na área laboral, na área da proteção dos trabalhadores, das remunerações, dos descontos para a segurança social. Temos, neste caso, 78 mediadores especializados, também em todo o território, neste caso continental, Portugal continental. Quanto ao último sistema que eu ia falar, o sistema da mediação penal, é um sistema que também foi instituído por uma lei, a Lei 21/2007, de 12 de junho, que deu cumprimento a uma decisão quadro do Conselho da União Europeia, já de 2001, quanto essencialmente à proteção da vítima e ao estatuto da vítima em processo penal, que determina que todos os Estados-membros da União Europeia se devem esforçar por promover a mediação no âmbito de processos de natureza criminal. Estão abrangidos por esse sistema de mediação penal em Portugal certos crimes semipúblicos, contra as pessoas e contra o património, e ainda crimes particulares, ou seja, aqueles que carecem efetivamente de queixa, em que o Ministério Público não pode acionar, não pode seguir se não houver mesmo uma queixa de quem, portanto, da vítima, não é? E têm que ser puníveis com pena de prisão até 5 anos ou com sanção diferente da pena de prisão, excluindo-se no seu âmbito, designadamente os crimes contra a liberdade e a autodeterminação sexual. São exemplos de crimes abrangidos pela mediação penal: ofensa à integridade física, simples, não agravada, difamação, furto, dano e burla. No contexto da fase de inquérito criminal, a iniciativa para esta mediação pode nascer ou da iniciativa conjunta e decisão conjunta do arguido e do ofendido, ou do magistrado do Ministério Público. Os senhores procuradores da República podem tomar essa iniciativa, sendo que em qualquer dos casos a participação e manutenção no procedimento é sempre voluntária, exigindo o consentimento expresso de todas as partes envolvidas. Uma particularidade deste serviço reside na total gratuitidade para todas as partes, seja ele o ofendido ou o arguido e o ofendido. Portanto, as duas partes são completamente isentas de qualquer pagamento. Caso haja, nesta mediação penal, um acordo, o mesmo é homologado pelo Ministério Público, que no fundo põe fim ao inquérito criminal, porque estamos a falar de uma fase de inquérito prévio à fase de entrada já do processo em tribunal. Está no âmbito do tribunal, mas numa fase prévia ao processo de julgamento. Nós temos neste momento 68 mediadores especializados na área penal, mas que ainda está em funcionamento experimental e disponível apenas em algumas comarcas, em alguns tribunais, sendo que é uma das razões que pode explicar a escassez de iniciativas que ainda nos dirigem. Este ainda tem muito menos conhecimento, e como o processo penal também, permitam que vos diga, não sendo este o nosso objetivo, é muito garantístico em Portugal. Nós temos um sistema muito garantístico, quer para as vítimas, quer para os arguidos, para as pessoas em geral. Começa logo na nossa Constituição da República. De facto, o processo penal, como já é algo de per si já muito garantístico, raramente ele é usado em termos de mediação, saindo fora do processo penal. Não, e agora aqui podia falar imenso sobre isto, mas não é o nosso objetivo, mas de facto ainda há muito... Há algum desconhecimento, continua a haver algum desconhecimento, poderá haver algum receio de fazer uma mediação dentro de um processo penal, porque ainda há algumas pessoas que fazem confusão se é mediação ou se é terapêutica, ou seja, porque uma coisa é terapia, não é mediação. Nós temos as duas distinções, aliás, como acontece muitas vezes com a terapia familiar, que há confusão muitas vezes com a mediação familiar e não tem rigorosamente nada a ver, mas estamos a fazer um caminho num sentido de chegarmos e alcançarmos mais pessoas. Estes sistemas públicos são geridos pela Direção-Geral da Política de Justiça, que está integrada no Ministério da Justiça. E quanto às estatísticas que partilho, que são as de 2023, posso dizer-vos que na mediação nos julgados de paz, o procedimento de mediação teve lugar em cerca de 30% da totalidade de processos entrados nos julgados de paz, situando-se a taxa de eficácia deste procedimento em 35%, em que findaram mediante a obtenção de acordo total entre as partes. No sistema de mediação familiar, portanto, falámos na mediação dentro dos julgados de paz. Agora, no sistema público de mediação familiar, apenas 50% dos pedidos de mediação que nos chegam dão lugar a procedimentos de mediação e como consequência do princípio geral da voluntariedade que vigora na matéria. A taxa de eficácia de procedimento da mediação familiar situa-se atualmente nos 40,50%. Portanto, está ali entre os 40% e 41% de eficácia, ou seja, de sucesso neste caso. A mediação laboral, temos um número de iniciativas mais baixo, até porque os tribunais de trabalho em Portugal funcionam sempre numa linha de obtenção de acordo entre as partes. É das áreas, das jurisdições especializadas em que há mais acordos dentro do próprio Tribunal de Trabalho. É fomentado esse acordo. E, portanto, também não se dirigem tanto à mediação, porque o acordo é feito logo nas partes no âmbito do processo laboral. E, portanto, isto também é uma das questões que nos têm vindo e que conhecidas. Aliás, eu já exerci advocacia há muitos anos e nos tribunais de trabalho a eficácia dos acordos prévios, logo na primeira diligência que é efetuada, é bastante elevada, em que as partes todas se reúnem com o juiz, com o procurador do Ministério Público, com os seus advogados. Portanto, já não há necessidade de ir para uma mediação laboral, ainda que haja uma eficácia dos processos laborais que, quando chegam à fase de mediação, têm uma taxa de sucesso de 40%, o que é bastante animador, ainda que sejam menos em termos de quantidade. No sistema de mediação penal temos, de facto, muito poucos processos. Em termos de sistema de estatísticas nacionais, nós estamos atidos ao sistema do Eurostat e ao nível europeu e internacional, quando são menos processos do que a média obrigatória para efeitos estatísticos, estão cobertos ao nível do segredo estatístico e nós não podemos retirar estatísticas porque eles nem sequer são listados. exatamente por isso, ou seja, são de facto relativamente poucos, porque nem permite extrair dados estatísticos. Em bom resumo, e em conclusão, eu gostaria muito de estar aqui a falar muito mais tempo e se calhar ilustrar até pronto, com mais dados, mas não vos quero amassar e vou dar já aqui um salto também para tentar terminar. Estes números dizem-nos que há uma ampla margem para crescimento das iniciativas relativas à mediação, todas elas, seja a mediação dentro do que é o julgado de paz, seja a extra-mediação dentro dos edifícios do julgado de paz e todos os sistemas de mediação que acabei de falar, e que é imprescindível garantir de forma muito consistente, é importantíssima, é a divulgação. A divulgação desta solução de justiça, que é uma justiça de paz, uma justiça de consenso, uma justiça voluntária, em que as pessoas têm que, muitas vezes o que falta, e como sabemos, é diálogo. E há muitos processos contenciosos, há muitos processos judiciais que começam por falta de diálogo. E digo-vos, também com esta experiência de alguns anos da justiça e também como experiência de advogada, especialmente na área familiar, há muita falta de diálogo em que basta haver uma sessão de mediação para que a barreira se elimine e as pessoas consigam atingir, que às vezes é por grandes coisas, pequenas vistas de fora, grandes obstáculos vistas de dentro. E por isso acho que nós consideramos que estas taxas estão continuamente a aumentar, nós vamos potenciar esse aumento e vamos tentar que haja cada vez menos taxas de rejeição a estes procedimentos. É importante envolver os tribunais, as magistraturas, obviamente também o poder legislativo, o poder executivo, para perceberem a importância destes meios de resolução alternativa de litígios, não é só como forma de retirar pendência aos tribunais, isso é muito importante, mas eu acho que mais importante do que isso é poder permitir que os cidadãos, as empresas, no fundo todos nós, tenhamos vários meios ao nosso alcance e tenhamos possibilidade de escolher o meio que nós preferimos e que nós legalmente podemos, obviamente, aceder. Assim, nós estamos muito empenhados nesta tarefa. O ano passado fizemos, o ano transato, um plano de comunicação destes meios. Temos vídeos nas nossas redes sociais, no nosso Instagram, no nosso Facebook, nas nossas páginas da internet. Podem consultar a nossa página, o nosso site. Temos dentro da nossa página da Direção-Geral uma página dedicada só aos meios RAL, com toda a informação, a toda a legislação. Qualquer cidadão em qualquer parte do mundo, é esta a facilidade que pode aceder. E ainda estamos a preparar, assim seja possível, uma campanha de divulgação ainda mais abrangente, com publicidade institucional, através das redes sociais da Justiça, canais de televisão nacional, imprensa escrita, outdoors e artigos até de merchandising. Já fizemos e vamos tentar fazer de novo e de forma ainda mais abrangente. A palavra-chave é comunicação. E é também passar a palavra, mas nos tempos de hoje é importante desmistificar alguns erros que as pessoas ainda têm, como aquela que eu disse há pouco, que muitas vezes acham que mediação familiar é terapia familiar, e até infelizmente alguns tribunais ainda têm esse equívoco. Não pode haver esse equívoco, tem que ser claro, porque é muito importante, temos que trabalhar em conjunto e em rede. Bem, a minha intervenção já vai longa, havia muito mais para partilhar convosco, porque esta atividade é de facto muito entusiasmante e por isso é que eu nunca posso deixar de estar também convosco e dar-vos nota daquilo que nós vamos fazendo, daquilo que nós estamos a construir em conjunto, e por isso contem com a Direção-Geral da Política de Justiça. É muito importante ouvir todas as experiências e também absorver ideias e exemplos e confrontar-nos com casos que nós podemos eventualmente incorporar no futuro próximo, e por isso deixo o palco às restantes partilhas. Deixo agora também ao Sr. Procurador da República, o Dr. João Rato, que muito me honra também estar neste painel com ele, bem-aja, portanto, estamos disponíveis. Alguma coisa que seja necessária da nossa parte, mesmo com colegas estrangeiros de outros países, por favor, contactem-nos, estamos disponíveis até para conversar, dialogar, encontrarmos as melhores práticas, porque é assim que o mundo evolui e é assim que nós encontramos e alcançamos a paz, tão fundamental para os dias de hoje. Muito obrigada e bem-aja a todos. Obrigada, professora Cátia, obrigada, professora Ana Maria. Obrigada. Bom dia, boa tarde ou boa noite.
Thank you so much, Director Lydia Jacob, for the landscape of the mediation policies that we are promoting in Portugal, and for the reality of the public systems that actually work in our country. So we will continue in Portugal, and we continue in Portuguese. I think that all that wants to listen to the translation already are available or is available to listen. So now I give the floor to Judge Counselor at the Supreme Court in Portugal, Dr. João Rato. Thank you so much for being here with us and for give us the court's perspective of promoting mediation in Portugal. Muito obrigado, Dr. João Rato, por estar conosco. Todos podem estar a ouvir a tradução através do Zoom e no chat estão a dar indicações sobre como ouvir a tradução. Thank you so much, Dr. João Rato, and the floor is yours.
Bom dia. Cumprimento a doutora Cátia, a nossa moderadora, a doutora Ana, a organizadora. Agradeço ao Instituto a lembrança e o convite e peço paciência a todos os participantes que nos estão a ouvir virtual ou presencialmente para uma pequena intervenção, tentando cumprir o horário como foi finalizado. Suponho que já vamos muito para além da hora reservada para o painel, e portanto eu vou tentar ser sucinto e começando pela felicidade de ter tido 3 intervenções anteriores que são um bom exemplo daquilo que nós, os juristas, costumamos, usando uma expressão anglo-saxónica, mas que é a diferença entre a law in the book e a law in action. Se temos Singapura, que nos dá um exemplo, ou 2 exemplos, aliás, de grande proximidade ou quase coincidência ou sobreposição entre a lei e a prática e os resultados, temos depois um quadro em Portugal que nos remete para um fosso, diria, abissal, entre aquilo que é o quadro constitucional e legal e as próprias infraestruturas já criadas e a realidade prática em relação à procura e ao sucesso da mediação como forma alternativa de litígio. Na verdade, o artigo 202 da Constituição Portuguesa, número 4, diz expressamente, consagra, reconhece, de certo modo promove ou estimula que os conflitos individuais ou coletivos podem ser resolvidos por meios e mecanismos e formas alternativas não jurisdicionais. E em Portugal, o que nós temos, e depois o artigo 209, que consagra expressamente os julgados de paz, que serão uma forma híbrida, não totalmente mediadora, porque, como a doutora Lídia referiu, é dentro do próprio julgado de paz que há um serviço de mediação. Eu aprendi que a mediação era, por natureza, voluntária, se não for, não pode ser. Os magistrados portugueses, incluindo eu próprio, ao longo da minha vida profissional, fui Procurador da República, agora sou juiz no Supremo Tribunal de Justiça, e como Procurador da República tive a felicidade de trabalhar vários anos na área laboral. E, na verdade, esse é um exemplo curioso, porque o Código de Processo de Trabalho tem um artigo que remete para o Código de Processo Civil, que, por sua vez, prevê expressamente a mediação como forma que deve ser estimulada pelos juízes e pelos procuradores de resolução do litígio. Só que, como na área laboral e mesmo na civil, os nossos códigos de processo prevêem também uma série de situações de encontro entre o o juiz e as partes, e o nosso legislador entende que sempre que as partes estão na presença do juiz, este deve ele próprio, enquanto autoridade, não como mediador, promover o acordo. Só que depois, como eles não são mediadores, os acordos nem sempre funcionam bem, mas apesar de tudo, as pessoas acabam por recear o resultado daquela proposta autoritária, não mediadora, da resolução do litígio, e daí o aforismo popular é que todos nós conhecemos, do povo português dizer que mais vale um mau acordo do que uma boa demanda. Mas este paradoxo de as pessoas acreditarem nas virtudes do acordo, ainda que mau, ou pelo menos não totalmente coincidente com as aspirações de cada um dos litigantes. A verdade é que depois as pessoas vão sistematicamente recorrer à litigância e têm alguma aversão, a começar pelos magistrados, que porventura precisarão de ser mais sensibilizados, até na área da formação profissional, para incentivarem o recurso à mediação, mas porque os próprios querem ter uma decisão de uma autoridade. É ao juiz que reconhecem, como se ainda estivéssemos no tempo em que se dizia que felizmente há juízes em Berlim para combater os ditadores do leste. Na altura não eram ditadores, mas eram czares e outros que fizeram isso. Bom, explicar para quê? A doutora Lídia falou-nos no relativo sucesso da mediação nos julgados de paz e também na família. Para termos uma ideia completa da dimensão desse relativo sucesso, seria talvez conveniente saber quantos casos é que os julgados de paz tiveram, para depois sabermos, em termos numéricos, qual o valor daquela percentagem de 40%, aquela que fez referência. Na área da família e menores, é, é muito escasso o recurso à mediação, apesar de termos mediadores certificados e qualificados para isso e termos espaço nos julgados de paz para o exercício dessa função. Os custos são, de facto, insignificantes. O resultado, quando bem sucedida esse recurso à mediação, é seguramente pacificador, como, aliás, os nossos colegas de painel de Singapura quiseram salientar. E, portanto, eu gostava de perceber, para além dessa tendência dos portugueses para se submeterem ou quererem ter uma decisão judicial, porque isso é tão importante, se isso é só uma questão cultural ou se é também, de certo modo, alguma consequência do facto de nós termos vivido muitos anos sob um regime fechado, que levou as pessoas a desacreditarem em que a pertença associativa e corporativa era imposta, se isso tem alguma coisa a ver com alguma relutância, ainda hoje também, dos advogados, para além do crescimento exponencial dos advogados e da explosão natural dos direitos e do exercício dos direitos a que as pessoas não estavam habituadas, se isso tem a ver, tudo misturado, dá o excesso de advogados, ou o número elevado de advogados, que têm a vantagem de promover esse exercício dos direitos, têm ao mesmo tempo alguma uma força contrária à promoção da mediação, porque a mediação não permite prolongar o processo e, portanto, os honorários seguramente ficarão reduzidos. Eu estou a falar nisto, parece uma brincadeira, mas é muito sério, porque eu já falei com alguns advogados, meus amigos, e eles dizem com frequência que os advogados se degladiam para obter as causas e para ficar com os clientes. Enfim, às vezes a deontologia profissional esquece-se um pouco, porque é preciso. E o Ministério Público, por exemplo, que tem funções importantes na área laboral, mas não é mediador, o procurador não é mediador, tem o dever de promover a conciliação, mas quando o faz, não tem formação, nem perde a sua qualidade de autoridade. E, portanto, não estamos a falar de um mediador, quer na área do contrato de trabalho, quer na área dos acidentes de trabalho. E, portanto, tudo isto misturado, talvez me permita concluir, como a doutora Lídia, que o importante era nós, na verdade, atacarmos pela área da formação, não apenas dos magistrados, mas dos cidadãos em geral, de que há um serviço, os brasileiros servem na área da lusofonia, servir-nos-iam como um exemplo extraordinário, em que a mediação tem, de facto, um espaço próprio e já bastante consolidado, e o modo como eles conseguem transmitir à população que há formas de resolução de litígios alternativas que não sejam os tribunais, talvez nós aí possamos aprender alguma coisa em termos comunicacionais e fazer campanhas que tenham algum impacto junto de quem tem a direção dos processos, se e quando as pessoas, apesar de tudo, continuarem a recorrer em primeira linha à litigância judicial, no processual normal, e também junto da população para que a crença nessa capacidade mediadora e de resolução em que eles próprios são os protagonistas da solução que vão encontrar para o seu litígio, seja assumida como a melhor forma. Eu, enquanto magistrado, não tenho dúvidas nenhumas que, tirando a área penal em crimes mais graves, que aliás estão excluídos do sistema legal português da área da mediação, a maior parte da litigância, mesmo na área penal, que ainda está numa fase experimental ao fim deste ano todo, e que eu saiba, nos últimos anos, com 0 casos, não é pouco, já 0, pelo menos no Porto. Eu fui diretor do DIAP regional e da comarca do Porto, e nós não tínhamos, é uma das comarcas onde era a mediação penal podia ser usada e pode ser usada a título experimental, e não há um único caso. Sei que a Procuradoria-Geral da República Portuguesa, nos últimos tempos, tem tentado promover o renascimento, digamos assim, da mediação penal, essencialmente na área da violência doméstica, onde se impunha por maioria de razão, mas o resultado até agora, digo eu, nos últimos anos, pelo menos conhecidos do Ministério Público, e portanto o Ministério Público é que tem que mandar as pessoas para a mediação, é 0. E aqui temos que encontrar alguma explicação. E eu, sinceramente, para além daquilo que já disse, não encontro outras, a não ser lamentar o estado das coisas em Portugal e manifestar aqui a minha veemente crença e, e vontade de que o panorama se altere no sentido da mediação passar a ser uma forma natural e recorrente de resolução dos litígios, mesmo quando haja processos pendentes em tribunal. E a forma de acabar. E, portanto, se houver alguma hipótese de debate e quiserem fazer de forma alguma questão, eu estarei ao vosso dispor. Até lá, fico-me com esta ideia do paradoxo que eu não consigo ultrapassar. Obrigado a todos.
Muito obrigado, doutor João Rato, por de facto ter assinalado que ainda há obstáculos que têm que ser ultrapassados para que a mediação passe a ser in action e not only in law. E de facto os advogados são um ponto-chave e têm que ver a mediação também como uma forma de ganhar dinheiro, caso contrário não vão de facto apostar nesta forma de resolução de conflitos. Eu penso que as coisas ultimamente e depois da pandemia mudaram de alguma forma e as grandes sociedades de advogados e as grandes empresas começam a olhar para a mediação de forma diferente, mas ainda há muito para fazer e fica a promessa de organizarmos em Portugal um evento para que possamos se calhar explorar melhor as razões pelas quais a mediação tem algum sucesso, mas ainda não tem o sucesso desejado, designadamente no âmbito penal. Muito obrigada por de facto ter aflorado esses aspectos, porque é também analisando os obstáculos que nós podemos fazer mais pela mediação no nosso país. Thank you so much. And we will continue for our last speaker. We continue in Portuguese. So for whom wants to listen to the translation, please continue on the instruction or follow the instructions that were sending to you. So now we will see a video because the judge Marco Aurelio Buzzi, it was not possible to be here at this time, so he sent us a video, and we will put the video to you listen. Marco Aurelio Buzzi is judge on the Superior Court of Justice in Brazil. And I want to thank you to Dr. Marco Aurelio Buzzi, or the judge Marco Aurelio Buzzi, for being here with us, even through a video. So Ana or Maria, can we see the video? Thank you.
Inicialmente, eu gostaria de cumprimentar a todos que participam do Singapore Convention Week 2024. O tema nosso é o Oriente encontra o Ocidente, um diálogo jurídico de mediação entre os países de língua portuguesa e Singapura. O nosso painel diz respeito à institucionalização da mediação nos sistemas legais e governamentais. Eu desejo inicialmente cumprimentar os integrantes desse painel. Eu me chamo Marco Aurélio Gastaldi Buzzi, sou juiz de carreira, atualmente exerço a função de ministro no Superior Tribunal de Justiça do Brasil. Cumprimento a juíza distrital Yon Loy, representante de Singapura na mediação familiar nos tribunais de Singapura. Cumprimento a doutora Lídia Jacob, diretora-geral da Direção da Política de Justiça em Portugal, experiências do Sistema de Mediação Pública em Portugal. E também cumprimento a doutora Ana Maria Maia Gonçalves, representante dos países de língua portuguesa. Por que nós estamos comentando nessa nossa apresentação a institucionalização, ou seja, a oficialização dos sistemas de mediação, de resolução de conflito nos países do mundo inteiro? Eu creio que o que tem colaborado muitíssimo para isso é a grande demanda que o ethos vivendi da sociedade de consumo instaurou, e esse consumo acelerado, esse consumo muito grande de bens e serviços no mundo inteiro tem ampliado os conflitos. Obviamente, amplia-se a compra e venda de bens, amplia-se o consumo de serviços, amplia-se consequentemente também os litígios, os conflitos entre as pessoas e as instituições. No Brasil, nós tivemos o nascedouro dessa vontade de construir um sistema consensual de composição de conflito, na época em que tínhamos aqui no Brasil uma instituição chamada Juizado de Pequenas Causas. Ele foi um juizado informal, absolutamente informal, funcionou durante um largo período no Brasil, sem ter leis, ainda que houvesse já esse nome. Foi algo criado pelos juízes de direito, destacadamente do interior do país, e posteriormente oficializado através de legislação, e posteriormente foi aperfeiçoado, e atualmente nós temos os juizados especiais sob a égide da Lei 9.099, que trata de um modelo mais simples, mais ágil de composição de conflitos, e trata também, especialmente, de uma audiência preliminar absolutamente informal na tentativa de compor os conflitos. Aí nós tivemos o início dessas nossas práticas, muitas vezes sem apoio do próprio Poder Judiciário. Eram os juízes que traziam esses métodos de composição, então, na época, absolutamente informais, e só com a emenda constitucional número 45 de 2004 é que nós pudemos realmente trazer para dentro do judiciário uma política nacional, ou seja, não algo regional, algo segmentado, mas sim no Brasil inteiro. Com a emenda constitucional número 45 de 2004, nós tivemos a criação e posteriormente, logo em seguida, por uma ação do ministro Jobim, nós tivemos a instalação. Então tivemos a criação e a instalação do Conselho Nacional de Justiça. O que é o Conselho Nacional de Justiça no Brasil? É um órgão é o segundo órgão na hierarquia do Poder Judiciário, só está abaixo do Supremo Tribunal Federal, e é um órgão oficialmente encarregado das políticas públicas do Poder Judiciário em âmbito nacional. Como vocês todos sabem, felizmente o Brasil é um país do tamanho de um continente. Nós temos muitas realidades díspares e o Conselho Nacional de Justiça foi o primeiro órgão em toda a história do Judiciário Nacional, no Brasil, a realmente se encarregar de estabelecer políticas em âmbito nacional. E no nosso caso da mediação, isso foi muito bom, porque nós tivemos, a partir do Conselho Nacional de Justiça, a edição da resolução número 125, foi o primeiro normativo, nos últimos tempos, o primeiro normativo, a estabelecer efetivamente esses métodos, essas práticas consensuais de solução de conflito. Foi na época do governo do ministro Jobim, que, em razão da emenda constitucional número 45 de 2004, com a criação e a instalação no governo do ministro Jobim do Conselho Nacional de Justiça, nós então introduzimos como meta institucional do Poder Judiciário também esse modo extrajudicial de resolver conflitos sem a necessidade, portanto, de você ter que entrar na justiça propriamente dita com uma demanda, com um processo judicial. Isso, a partir de 2006, nós tivemos então o lançamento do programa chamado Movimento pela Conciliação. Aí foi sob a égide da ministra presidente do Supremo Tribunal Federal e do Conselho Nacional, a ministra Ellen Grace. Depois, com Gilmar Mendes, com Peluso, com os demais presidentes do Conselho Nacional de Justiça, nós tivemos a proliferação daquilo que inicialmente se chamou posto de atendimento e conciliação, que era voltado a atender as populações, destacadamente as mais simples, as mais pobres, nesses casos menos complexos de eventuais conflitos, envolvendo preponderantemente direito do consumidor, direito de família e direito de vizinhança. Com o aperfeiçoamento desses postos de atendimento e conciliação, nós tivemos, alguns anos mais tarde, a criação dos Conselhos Nacionais dos Centros Judiciais de Solução de Conflitos, os CEJUSCs. Hoje nós temos, se não me falha a memória, nós temos aproximadamente quase 1.930 CEJUSCs, que são centrais de conciliação, espalhadas pelo todo o território nacional. Nós não temos mais nenhum estado dentro do país, nenhuma capital dentro do país, dos estados, ou como alguns chamam ainda, províncias, né? Não temos mais nenhuma capital que não tenha uma central dessa de solução de conflitos. Nenhuma cidade de porte grande e porte médio existe no Brasil que não tenha uma central de solução consensual de conflito. Então, hoje em dia, podemos dizer, sim, que no Brasil essa política foi muito bem instalada, está funcionando muitíssimo bem. Nós temos um exemplo, como o estado de São Paulo, que é o estado que economicamente o mais pujante do Brasil. Em algumas unidades, nós chamamos aqui de varas judiciais, unidades judiciais, onde funciona um juiz, e no atendimento aos processos que na vara dele tem entrada, nós com os CEJUSCs chegamos a resolver muitos meses, 30% de todas as demandas que entram. Então, se entrou nesse mês um número de 1.000 processos, 300 processos, nós vamos conseguir resolver dentro de uma solução consensual dentro dos CEJUSCs. Então, isso é um belíssimo dado. Depois da resolução 125, o próximo normativo que integra uma tríade de normativos voltados para esse fim é a Lei 13.140, que aqui no Brasil é chamada de Lei de Mediação. É uma lei excelente, não é? Ela veio restabelecer aquilo que nós já tínhamos no tempo do Império, na Constituição de 1824, no artigo 160 ou 161, os métodos também consensuais de solução do conflito. Veio resgatar novamente essa Lei 13.140. É chamada de Lei de Mediação, mas na verdade quase metade dessa norma trata da autocomposição, que nada mais é do que a solução de conflitos com o Estado, Então essa lei, a 13.140, trata da solução de conflito entre particulares e também entre o particular e o Estado, ou entre o Estado e outro ente também estatal. Foi um grande progresso para nós aqui no Brasil, porque destacadamente os juízes da área federal, da Justiça Federal, faziam já essas composições, esses acordos, praticamente sem ter uma lei específica para ampará-los. E eles utilizavam então um princípio geral, né, constitucional, um princípio geral do direito, que é o melhor interesse do Estado, quando um dos integrantes da relação conflitada era o Estado. Então, sem um legislativo próprio, ainda assim tínhamos como resolver esse conflito. Agora não. Agora com a 13.140, felizmente, essa ausência de normatividade foi superada. E também faz parte desse microsistema, desses normativos que integram um microsistema propriamente dito de solução de conflito, o atual, alguns chamam de novo, não é mais, é o atual Código de Processo Civil, de 2015. No artigo 3º, parágrafo 2º, ele deixa bem claro que todos aqueles que militam na área da justiça, sejam juízes, advogados, promotores, procuradores, afinal, todos que militam, todos os operadores do direito devem privilegiar a solução consensual de conflito. Portanto, é um normativo que mais crava um princípio dentro do nosso sistema legislativo, prestigiando também esse método de solução de conflito. E eu tenho aqui anotado que esses núcleos nossos, dentro do SIJUSCs, nós estamos formando núcleos de capacitação. Para quê? Para ter, além dos mediadores comunitários, os mediadores judiciais. Esses mediadores judiciais, o próprio nome já diz, judiciais, são pessoas que são especificamente preparadas em cursos de formação para atuar junto com o juiz dentro dos processos judiciais, realizando aquelas audiências que estão previstas no artigo 334 do atual Código de Processo Civil, que é uma audiência, muito embora não tenha esse nome, mas é uma audiência preliminar de tentativa de composição de conflito. Como temos também na 9.099, no Juizado Especial, o primeiro ato dentro da audiência, que se realiza lá nos Juizados Especiais, também é um ato destinado à tentativa de composição do conflito. Temos lá nos juizados especiais e temos aqui no juizado comum, no juizado geral civil, essa audiência que pode propiciar já um acerto antes da própria formação da relação processual, antes da própria contestação, antes do oferecimento da contestação. Interessantíssimo isso. Temos também outros normativos dentro, por exemplo, da recuperação judicial. Nós temos também um incentivo, é a Lei 14.112 de 2020, sobre também a prevenção e sobre também a possibilidade de se fazer acordos com todos os credores ou com uma parcela dos credores e tentar resolver de um modo mais ágil, célere, o conflito envolvendo recuperação judicial. Aqui cabe lembrar que nós tivemos um caso que envolvia uma grande empresa de telefonia, que nós aqui no Brasil, em 6 meses, fizemos 35.000 acordos dentro de uma demanda de recuperação judicial. Então veja como essa iniciativa, que agora está efetivamente regulamentada, é interessantíssima e oportuníssima. Nós temos desafios e o fortalecimento desse sistema. Então, para que seja fortalecido esse sistema, mantido, fortalecido e aperfeiçoado, eu tratei de separar aqui algumas metas, não que não existam outras, mas algumas metas, alguns objetivos. Um deles é a formação de mediadores, com a oferta contínua de cursos de formação e aperfeiçoamento dos mediadores, o incentivo à utilização dessas práticas de mediação, como está ocorrendo, em razão da Resolução 125, da Lei 13.140 e do atual Código de Processo Civil. E com isso nós iremos obter, ou obtemos, a redução do tempo e a agilização das demandas. A redução de tempo para a solução dos conflitos. A média no Brasil, num processo civil comum, é de 6 a 8 anos, com o desenvolvimento do processo regular, comum. Já nas práticas consensuais, a média no Brasil é de 30 a 60 dias para a solução definitiva do conflito. Nós temos aí envolvido a redução dos custos, muito grande a redução dos custos, é um grande benefício para o Estado e para as partes. A maior satisfação das partes, por quê? Porque a decisão, a solução, melhor dizendo, não é dada por um juiz que está, obviamente, ligado à lei. O juiz não pode dar uma decisão do jeito que ele bem quiser. Mas as partes não. As partes, desde que não construam uma solução ilícita, podem dar ao problema a solução que bem entenderem. Então a tendência é que a solução construída dentro de um acordo seja muito mais satisfatória do que a solução que provém de uma sentença judicial, porque a sentença judicial está agrilhoada aos artigos da lei, né? O acordo necessariamente não. A prevenção e a preservação dos relacionamentos, não é? Então, com a mediação, aquele conflito que muitas vezes, destacadamente no Brasil, quando o conflito envolve terras, posse, propriedade, ele gera inimigos, algumas vezes gera consequências gravíssimas, até homicídios. E com a tentativa de composição ou com esses meios consensuais de solução do conflito, nós trazemos a pacificação das pessoas. Eu sou juiz de carreira, eu presenciei muitas vezes isso. A realização de um acordo quando envolve questões de terras, propriedade ou posse de terras, você resolvendo pela sentença, você resolve o conflito judicial, mas não resolve o conflito social. E quando você consegue resolver com um acordo, você resolve tanto a demanda ou a futura demanda, quanto o conflito social. Você muitas vezes reaproxima as pessoas. O descongestionamento do judiciário, como falei no início da minha manifestação, hoje aqui, nós temos varas em que oficialmente nós já constatamos a redução imediata em 30 a 60 dias, entre 30 a 60 dias, de aproximadamente 28 a 32% do número de demandas que iriam ou que vão tramitar no judiciário, levando anos e tendo um custo elevado tanto para o Estado, por causa da organização do Poder Judiciário, quanto para as partes, por causa das despesas com os atos processuais. Então eu desejo muito sucesso a essa convenção de Singapura. Eu tenho uma grande honra estar participando desse evento e, com certeza absoluta, é um evento que é global, vai atingir praticamente o mundo inteiro. E é um belo discurso, é uma bela bandeira, é uma bela motivação. Portanto, nós temos plena certeza de que esse evento será mais um fator de contribuição muitíssimo importante para o incremento dessas políticas voltadas à resolução consensual dos conflitos. Não que seja necessariamente longe do Poder Judiciário, claro que não, mas sem a necessidade de uma demanda judicial propriamente dita, não é? No Brasil, esses sistemas consensuais são, sim, fiscalizados. A própria Resolução 125 deixa isso muito claro. São, sim, fiscalizados por todos os operadores do direito. Não só pelos juízes, pelos promotores, pelos advogados, pelos procuradores, pela comunidade, pelo Conselho Nacional de Justiça. Isso é ótimo, isso é excelente. Então, com muita alegria, encerro aqui a minha fala e manifesto mais uma vez o meu grande agradecimento, meu pleno agradecimento a esse gentilíssimo convite feito a mim de participar muito honrosamente deste evento. Muito obrigado. Felicidade a todos.
So with this video, we finished the first panel. It's quite interesting to realize that all the interventions and to all the speakers, and I thank a lot to all speakers that participated in this first panel, give us the idea that we cannot work separately, and all the powers, the powers that are involved in the justice sector have to work together in order to promote alternative dispute resolution and specifically mediation. So thank a lot, and we will start in just now the second panel. And I think our moderator, Professor Nadja, will be here. Hannah, you will pass to the next panel. Thank you so much.
Thank you, Katia. Yes, thank you, Katya. Thank you all panelists, and for what was for me an insightful discussion about the institutionalization of mediation in legal and government systems. And now we'll move to panel 2, which will explore the legal frameworks of mediation in Portuguese-speaking countries and Singapore. This panel will provide a comprehensive overview of mediation legislation with contributions from different distinguished legal scholars and academics. And I'm pleased to introduce, first of all, our moderator, Nadia Alexander. Nadia is a highly respected professor of law at Singapore Management University and the director of the Singapore International Dispute Resolution Academy. With her extensive experience in dispute resolution across more than 40 countries, Nadia is really a recognized global thought leader in this field. And Nadia, thank you very much for being here with us. You know how grateful I am, how thankful I am for you to being our moderator here tonight. And over to you to lead us through what promises to be, I believe, another engaging discussion. Nadia.
Thank you, Anna. Thank you very much for the warm welcome. Hello, everybody. This is a topic that's very close to my heart, and I think all of our panelists are also as excited as I am to engage in the topic of legal frameworks in mediation across Lusophone countries and Singapore, of course. So you have, I know, details of our speakers, but let me introduce them briefly. And also, before I do that, Anna, let me thank you. I mean, this is, I was talking to you months ago when you had the idea and you were starting to develop this, and this is just an amazing effort. So thank you to you and to the ICFML for putting on really a tremendous event. So before further ado, I would like to introduce, do we have Dorcas here? Dorcas, hi Dorcas. Dorcas is actually my colleague at Singapore Management University. She's an associate professor of law at the law school. Makes sense, professor of law at the law school. That's why I hesitated. Welcome, Dorcas. Nice to see you. We also have Katya, who everybody knows by now. Katya Marques Cebola, assistant professor in Portugal, focusing on alternative dispute resolution and civil law. All right. Umberto, welcome, Umberto. Umberto Dalla Bernardina de Pino. I should have practiced that. I hope that's a grand name, Umberto. Professor of Civil Procedural Law in Brazil. And Nuno Albuquerque. Hello, Nuno, lawyer and a founding partner of the law firm N Advocados in Africa. And Bruno Nunes, managing partner, hello Bruno, of BN Lawyers in Macau. All right, so we have a very diverse group. We're going to run this panel in the following way, I hope. I believe we have an hour. Anna's going to tell me if I get something wrong with that. And we're going to run this across themes. So rather than each presenter present just one piece, we're going to talk about, we've got 5 questions that we're going to go through, and I'll get each of the panelists to respond to those questions. So as we do that, what I would do is encourage you in the audience, if you have a question, to put it in the chat. Right? And if it's relevant to the topic we're talking about, I can feed it into our conversation. I can't promise that we will be able to deal with all of the questions. And I said to Anna, we wouldn't be here until midnight in Singapore time, although I know we could be, but I'll do the best I can. So I really want to encourage questions from you as well. All right, so let's get started. I want to start, we're going to look at different aspects of legal frameworks. And I want to start by asking each of you, in your jurisdiction, or the one you're talking about tonight, how do matters get on the mediation pathway? Sometimes I use the word mediation triggers, right? How do people, what incentives are there? How do people get to mediation? And sometimes we might talk about mandatory and voluntary, but I think the landscape's more sophisticated than that and more nuanced. So I want to draw out some of those nuances. I might start with, I'm not going to necessarily go in order that I've got here, but I might start with Bruno. I might start with you.
Oh, thank you, Nadia, and thank you, Anna. Hello, everyone, my fellow panelists. It's a joy to be here. So basically in Macau, and as I will point out throughout my presentation, it's a bit of a patchwork of different laws that have evolved, but not in a consistent way. So I would say that there are different pathways to mediation that are set out within different laws in Macau and with different institutions. The main aspects is that it's always voluntary and that the parties retain their ability to make or not concessions whether they feel right, being that the overseeing entity, be it the court or different institutions, role is to ensure that the legal rights of the parties involved in mediation are, observed. They are not, there's no compromise to those rights. So there are different triggers to mediation. I would say, for example, one that's very, very common is the one that regards medical error. When somebody suffers damage caused by medical error, it is the one key area where mediation has been pushed throughout with most effort by legal authorities. And I would say that there are advantages that are set forth in this area. There are other areas like consumer protection areas. There are other situations like common management of buildings where mediation is enforced, but unfortunately, with the exception of the medical error, it's all based on voluntary action by the parties.
Aqui conectou automático.
So just to sum up, basically voluntary, but in certain areas, for example, the medical, sort of a stronger push or some more incentives to encourage people to go. I might move to Brazil, Humberto. What's the pathway? What are mediation triggers like in the Brazilian legal framework?
Thank you so much, Nadia. Thank you all. It's a great pleasure to be here. We have arranged some topics to talk today, and we are beginning with the pathways. As Justice Marco Buzzi had already said, Brazil has gone through a long way until we finally had a mediation act. We started our first legislation works in 1998. In 2009, we started the movement to update our civil procedure code, which was ended in 2015. And at the same year, we've approved with the participation of Justice Buzzi and Justice Salomon, and I had the honor to integrate that group of Brazilian professors and judges. We finally got approved with the Mediation Act. So we have in Brazil a mediation that goes through the judicial system, but we also have the private chambers, the private mediators that can work in several and different areas, in family matters and liability, in medical issues, in cases involving minors and people that need some kind of special support from the state. And nowadays we are developing new areas in Brazilian mediation. We are working in administrative questions, even involving public entities. In criminal law, we have at least 3 different ways of achieving a consensual solution regardless the type of crime. They're in some specific situations, for instance, in domestic violence, in questions involving this kind of violence, and even you were you were able to find a peaceful solution that does not prevent the criminal process. So in most of the cases, the offender is going to be indicted, accused, and sentenced, and probably he's going to prison for that. But that does not prevent a possible settlement between them in order to arrange other matters like the division of their belongings, like who's gonna take care of the child, if they're gonna make it together with a third person. So there are some cases in Brazil in which you can find a settlement, you can find a consensual solution, and the judicial process is over, or even you won't have a judicial process. And in other cases, you have the two pathways. You are going to have a judicial process, as happens in domestic violence, in some criminal procedures, and procedures in which we are investigation public officers, public servants for having committed a crime or an act that can attract to them some kind of civil liability. And even then, we can try to achieve a consensual solution. So I would start with these initial remarks. Thank you, Naja.
Thank you very much. So just to sort of sum it up very quickly, again, basically voluntary pathways to mediation, but you talked about some of the different areas where mediation is opening up, and one of those was, for example, in criminal matters, domestic violence, and others. All right, thank you. I might go to Singapore now, if that's okay, Dorcas. Tell us the pathways in Singapore.
Hello, everyone. Yes, I'm a colleague of Nadia. So in terms of the pathways to mediation, I think it was alluded to by the Ministry of Law, I think the earlier presentation. But just to sum up, probably a few strands. Those that are in court, that means cases that are filed in court, which might cover a range, civil, criminal, or family. For civil, I think over the years, what happened was it was strong encouragement by the courts in pre-trial case management conferences. So really very much education and strong encouragement for them to try mediation. And to make it easier, so for the lower courts, like the district courts, the mediation is actually provided by the courts. So we also heard from District Judge Yani that initially, so it was just experiments in terms of providing mediation in family courts. But you can see that over the years, as there was more familiarity with mediation by lawyers, in some areas it has become mandatory for certain types of disputes in courts, whether by way of legislation or some other way to actually direct those cases as a matter of course. Some of these cases, broadly speaking, these kind of cases where it's mandatory is where it has been deemed to be, because of public interest, important for the non-adversarial approach to be adopted, such as matrimonial cases where family is affected. We also have personal injury cases, as well as sometimes very low value cases below 60,000 in Singapore dollars. So those are the main pathways, probably a mixture of strong encouragement by the courts, as well as for certain kind of disputes is mandatory. And then outside the courts, I think the main pathway is that there have been very specific developments within each sector. Say if you're in the medical profession, they will try to have these kind of mediation options made available when there's a start of, say, a complaint, maybe a complaint against a doctor to the Singapore Medical Council. So they try to infuse some of these programs into perhaps complaint systems for different industries. And then those kind of mediation services are then provided by well-established centers like Singapore Mediation Center. So that's how I'll probably sum up the different pathways in Singapore across sectors.
Great, thank you. So would it be accurate to say, to reflect on what you've said, that that initially it began experimenting and voluntary in nature, and while it's different in different sectors or different areas, there are increasing incentives, and in some cases, and you talked about the family court, it might be mandatory. Yeah?
Yes.
Right, okay.
Thanks.
And I mean, for me, this is interesting as I'm sort of going around the different jurisdictions. We're looking here primarily, I think, at civil law jurisdictions, but of course, Singapore is a common law jurisdiction. And so far in our civil law jurisdictions, it's been a primarily mandatory set of pathways. So but let's go to you, Nuno, and then we'll go to Katja after that. Tell us about what's happening in the African region. I think you're on mute, Nuno. I'm wondering, Anna, if someone can help Nuno unmute.
Yes, I was in mute, so sorry. Thank you very much, Najaf, and thank you to ICFML to invite me again. It's a pleasure for me to be here speaking about the mediation in the Lusophone Africa litigation countries. So what can I say? The first thing is that mediation is not yet part of the overall Lusophone Africa litigation tradition. One important step, that of providing a practicable legal framework for mediation, has already been implemented in Angola and Mozambique. Cabo Verde is also working on. In Angola and Mozambique, mediation is completely voluntary. In Angola, the starting point is the constitution of the country, which provides for the legal creation and implementation of means and forms of court conflict resolution. This includes arbitration, mediation, conciliation, and negotiation. So in Angola, we have a law governed the mediation law. These laws say regulate the mediator rights and duties and mediated centers. This is very important because we have some mediation centers in Angola. One special, it's a public mediation, it's CREL. It's a mediation implemented by the government. Is Centro de Resolução de Litígios, the Center for Mediation and Arbitration. So what can I say? The special incentives for mediation in Angola, we can find it in the mediation law for now. Of course, we have a long way to go to the lawyers, to go to the judges, to go to the people, to understand how we can work with mediation. But it's very important, this law, because this law provides that agreements reached through mediations are directly enforceable. So it is very, very important. We know it's why we have the Singapore Mediation Convention, and also in the national law, it's very important. But it's a voluntary process whereby the parties will suspend their judicial proceedings to conduct mediation. So in Mozambique, too, the state has promoted mediation through mediation centers. The first notable example in Mozambique is the Comissão de Mediação e Arbitragem Laboral, the COMAL, Labor Mediation and Arbitration Commission. COMAL is a public institution established in 2009 that offers service as the management and prevention of labor disputes, technical support, promoting dialogue between employers and workers, and so on. So COMAL has centers in all the provinces of Mozambique. Noteworthy, it's the fact that in Mozambique labor law provides for mandatory labor mediation for prior to litigation or arbitration. So this is the first step I can told you for Africa mediation Lusophone countries.
Thank you very much. And you talked about in Angola and Mozambique, mediation primarily still being voluntary in nature. You also talked about the different incentives, particularly through the legislation, I think. And we'll come back to different parts of that legislation later. And also you talked about the work of some of the mediation centres and institutions to help incentivize. So that was really helpful. Thank you, Nuno. And last but definitely not least for this first question, Katja, tell us, we're back to Portugal.
And we have already listened about the Portugal system, and as you heard before, in Portugal, mediation is completely voluntary because the law, the Mediation Act in Portugal prescribed that in Article 4. Nevertheless, the Court of Peace, or the peace courts that are established in Portugal since 2002, have a step before the audience with the judge, where the parties are invited to a mediation session. This session is still voluntary, so parties may not attend, but there is an invitation, and in some cases the parties accept, and as you heard before, in 30% of the cases we have an agreement, parties reach an agreement, so it's quite interesting. In judicial courts, especially in family courts, judges also invite parties and promote the referral of the cases to mediation. So in the public family mediation system, there are a level of success of mediation. So I think it's still voluntary, but this invitation really promotes mediation in Portugal. It is quite interesting. Additional, and to give you a nuance of the Portuguese regime, in the code, the Civil Procedure Code, we have a rule that states, that prescribe that if the plaintiff who present an action in court, he can be sentenced to pay the costs of the court if he can use ADR mechanism before and he didn't use it. So it's a rule that exists. It has never been fully implemented because we need to have another prescribed to implement that, but exists. And I don't know if someday the Minister of Law implement that rule. But so it is voluntary. We have invitation, and there are rule where the judge can sentence the parts that can use ADR mechanisms before and did it used to pay the costs of the judicial procedure. So it's quite interesting rule.
Thank you. And I think what's interesting in your comments is that you talked again, right? Portugal, civil law country, basically voluntary, but increasingly some stronger incentives, even some potential sticks in the form of a sanction if it's not used. And I think what you've really highlighted is the, I guess, continuum of incentives, right? What does voluntary mean? And on the other hand, what does mandatory mean, right? Because if a judge says to you, I really think you should mediate this case, and you're thinking, oh, I don't really want to, but if the judge asks me, it's voluntary, but maybe it's also not completely, right? And I think that's come through in the examples and illustrations that many of you have given, and I think that's been really helpful. I think you know, if you look in a very general way across the world, traditionally, as mediation's been introduced, common law jurisdictions have been quicker to adopt stronger incentives, and civil law jurisdictions less so, mainly out of principle. And I think that's echoed in your comments very strongly. So, ladies and gentlemen in the audience, we're going to cover a number of topics. We're going to get later on to sort of the harder legal topics like enforcement and maybe confidentiality, and talk about what's in the Mediation Act. But just before we get there, the next topic that we're going to broach, because it's also relevant to the legal framework, is, you know, to what extent are mediators or is the mediation community professionalized? To what extent is mediation a profession, or to what extent is it becoming a profession in your jurisdiction? I'll mix it up a little bit now. I'll start with you, Dorcas, if that's okay.
Sure, yeah. So I think that's an interesting question about...
Sorry.
Sorry? Oh.
I said I keep my speakers on their toes by mixing you all up. Sorry about that.
Yeah, that's a very good tactic. Yeah, so I think that question is interesting because it backs our respective opinions of what is professionalization. And that I think it's a perennial question that is being pondered across many jurisdictions. So by way of background, I used to be one of the district judges in the Singapore State Courts, where I provided mediation as well as early neutral evaluation services. And I was also involved in some of these early court policies to encourage the use of mediation amongst lawyers and consequently to their clients. So this idea of professionalization was something really real to us because we were thinking about the entire landscape of mediators within Singapore, right? You have mediators not only the courts, you have mediators outside courts. And as I explained earlier, the way it started in the early days, it was kind of different areas, so different sectors. You have community, you have commercial, you have the courts, and then there was experimentation across different spheres. So when you talk about professionalization, there's the challenge of how to have that uniformity, but at the same time have room for experimentation to take place as well as contextualization of mediation to each specific sector. So I think those are things we struggled with. So it took only in 2014. So I think it is notable that only in 2014, even though mediation was in place since the 1990s. In 2014, because it was a recognition that we need some kind of confidence, public confidence in mediators, and across the nation, and not just across the nation, also because we wanted cross-border disputes, right, to also be mediated in Singapore. So professionalization became almost an essential aspect. And that's when we have Singapore International Mediation Institute, SIMI for short, that was formed. And it was really tasked to come up with standards for mediators throughout Singapore. So it's a voluntary kind of accreditation system. So it is not mandatory. It does not say that you can only practice mediation if you have this. And in this respect, I think I would just like to comment so the head of SIMI is Professor Joe Lee, who's from National University of Singapore. I think it was quite a good step that they collaborated with IMI, which is also one of the co-sponsors today, International Mediation Institute. And we also know that the late Michael Leeds, who was the founder of IMI, has recently passed on. I think it was a good approach that we linked accreditation. So they collaborated with IMI, such that accreditation, there are 4 levels, but the same principle which IMI has was adopted, which is you move up the accreditation by doing more cases, but it's not just cases, but you get feedback from the parties. So from level 1 to level 2, so we were, if you move up the ladder, supposed to collect feedback from users, both lawyers and their clients. So that then is used by perhaps some other impartial mediator. They will look at some of these feedback, and then they actually will summarize what they think is the collective view of this mediator's style. So I think that the infusion of getting more experience, but not just cases themselves, because when you look at quality, the feedback, the opinion of users, I think really count. So having that in the system for professionalization, I think has been quite useful. I just a side point, because it's something I feel very strongly about when we're the courts and we're trying to so-called professionalize and get judges to think about if you're doing mediation, it is a profession. I think what's essential is not just getting cases, but also some kind of accountability. So SIMI has a code of professional conduct. It's also notable that the state courts has a code of ethics that is publicly available, and so they actually represent to people that these are the principles you abide by. So I think with professionalization, of course, you need to have hand in hand in that ways where there can be accountability. So I think all these things have to be there, so that there's accountability, and there are ways that mediators would know they need to take into account the opinions, the experience of the users.
Thank you, Dorcas. And I think you've started this conversation in a really beautiful way, also by discussing what do we mean by professionalization, right, and some of the issues there. And so again, to sum up really briefly, mediation was around for a while before the need for, I guess, a uniform standard emerged, and that is through SIMI primarily. But most of the regulation around it is not in legislation. Actually, none of it really is. It's in soft law and through institutionalization. And then you also talked about the link between SIMI and IMI, right, in the system there. All right, thank you. Let's move to Macau if we can. Bruno, can you tell us about professionalization of mediators?
Thank you, Nadia. You keep us guessing, huh? Who is the next one? So thank you. In regards to how mediation has been professionalized in Macau, I would say that with the exception of medical error mediation, where we can really see stringent requirements to be a mediator and what are the duties and how those duties are discharged, I would say that there's no professionalization of mediation per se, and that there are different requirements when we have different institutions. So, for example, we have two of the biggest institutions in Macau, which are the Macau World Trade Center and the Macau Lawyers Association. Both of them set up mediation centers in cooperation with a government bureau in regards to the close economic partnership between Macau and mainland China, in a way to address and to facilitate the resolution of cross-border economic disputes in a structured way. Now, the issue is that each one of these centers have different requirements for the mediators. Although it's within the same area, the Macau Lawyers Association Mediation Center says one thing, and the World Trade Center says another, which basically throws a lot of confusion into this area. But at the same time, and more recently in 2021 and 2022, there is this thing which is the Greater Bay Initiative, which basically aims to facilitate and create a Great Bay between 9 cities in Guangdong Province, Hong Kong, and Macau. And they have gone to set out the Greater Bay Area Mediator Accreditation Standards and the Code of Conduct for Best Practice. So basically, this sets out a uniform way of requirements and standards for mediators within the Greater Bay Area, which basically, I believe, will then trickle down to all the different institutions in Macau. But right now, I would say it's a patchwork. Each one of these institutions that I mentioned in my first intervention, they have their own set of rules, which basically makes it difficult to say, well, it is a profession. Thank you, Nadia.
Thank you. So it sounds like standards are there, right? Professionalization is becoming, it's emerging, but there are a variety of standards in relation to that. That's really interesting. I'm going to move to Brazil, and then just so that you know what's coming, I'll go then to Katia and then to Nuno after that. All right? So Humberto, over to you.
Thank you, Nadia. Well, in Brazil, we have this career of mediator, as I've said before. We have some mediators that work only in judicial processes. We have others that works just by themselves or connected to a private chamber of mediation. They can also be mediators and arbitrators. There is, although a special rule in our system in which if the private mediator try to solve the case, try to help the parties in that process, and the consensus doesn't come out, he can't turn himself into the arbitrator in that case, because he had access to some private information, because those parties shared with him some specific data, and so we think that would not be appropriate. So when that happens, when you have a mediation followed by an arbitration process, generally you have to use two different professionals. We also have a code of ethics for them. It's in a resolution of the National Council of Justice. And however, the requirements to become judicial mediators are quite different from the ones to be just a private practitioner. If you want to be a judicial mediator, you have to fulfill some requirements. You have to go through a specific course held in public institutions. You have to have a certain number of hours of practice, 40 or 60. I think it's 60 hours of practice under supervision of a senior mediator, and then you become like a public server. You have to go through an exam. You receive a payment, a salary for that. That does not prevent you from your private practice, so you can do both at the same time. But being a public mediator is going to force you to have some limitations in your practice. I think that's a summary of how things are going on in Brazil right now.
Okay, so what I got out of that is judicial mediators, public mediators, and then private mediators, and some different requirements for those. We also talked, I think, at the beginning about how the law regulates conflicts of interest between mediators and arbitrators, for example, or somebody double hatting, and I think that was an interesting point in this context. All right, let's hear from Katja about professionalization of mediators in Portugal.
Thank you, Nadia. Thank you for the question, because I think it's a key point if you want to promote mediation, because only with seeing a mediator as a professional, the other professions in legal sector can really accept mediation as a way to solve conflicts with the same guarantee. So Portugal adopted the European Mediation Directive in 2008, of 2009 actually, and in 2010 it was accreditation system for mediation trainings was implemented in Portugal. And in 2013, the Mediation Act in Portugal maintained that system, changed a little because now we don't have a certification for the trainings, but for the entities that promoted training. For instance, ICFML is a certified institution in Portugal to give mediation trainings. ICFML is also the unique entity for Lusophone countries that is a qualifying assessing program, and jointly with CME and the FICM and the Asia Mediation Center and the EDDR from China created the Alliance for Mediation Standards with this idea of professionalization across different countries. It is quite interesting. So in Portugal, these trainings are not mandatory for Portuguese mediators. However, without this specific training in mediation, the mediator cannot apply for the national registration of mediators. And if a mediator is not in this national list, the agreement that you reach in a mediation is not enforceable. So it's not mandatory, but indirectly, they are invited to, or they are forced to have this training, certified training, in order to say to parties, hello, I'm a mediator, and the agreement that you may reach is enforceable. So this is quite interesting system. On the additional, we have also accountability or liability professional system. So in the Mediation Act established that the DGPJ, the Ministry of Justice, can move a process to a mediator if a complaint is presented against him or she. So we have accreditation system for trainings. We have a national registration for mediators who have these certified trainings, and also we have a specific professional liability system in order to analyze if some practices, the practices of mediators are against the law or violate any principle of mediation. So we have these three main issues regarding the professionalization of mediators in Portugal.
All right, it's hard for me to sum that up because you've done it, so I won't. But I will say that I think what was interesting there is that you introduced the notion of professional liability and how there is a system in Portugal for that. And I certainly see parallels between what's happening in Portugal and Singapore. Obviously other countries, but I'll stick to the jurisdictions in this panel. And I believe that IMI is also affiliated with ICFML in perhaps a similar way that it is with SIMI. So there's another point of connection. All right, moving now. So it's about 8:15 in Singapore, and I think I'm looking at Anna. We have 20 minutes. Is that right, Anna? She's nodding. Is okay. All right. So I'll hand over to you, Nuno, to talk about professionalization, and then I'm going to pick up the pace a little bit so we get into our meaty legal topics as well. But tell us about the pathway of professionalization to becoming a mediator in Angola and Mozambique.
So in Angola and Mozambique, we don't have a list of mediators, a national list of mediators. We can say we don't have the profession of mediator, not yet. Of course, the CREL, the Center for Mediation and Arbitration, has created its studies and training service. It's advertises that it will start to provide training and capacity building courses on a regular basis in partnership with other Angolan and foreign entities. However, in Angola, there are not an accreditation system for organizations that provide mediation training. So organizations that provide mediation training in Angola are not obliged to be accredited. We don't have compulsory courses for Angola mediators and a list of duly accredited national mediators. I think this is one of the steps we need, especially in Angola, to do its mediation training accredited to after we can build the profession of the mediator. So there isn't any incentive to training for mediator, especially the mediator courses are provided for local entities. I know the national government is trying to work with foreign entities, especially with ICFML, to provide some courses, but we are pushing the things to going on.
Thank you. So an area for growth. We'll expect to hear more from you in a year or so, Nuno, about all the exciting developments there. So, and it's in a way, it's great to have a blank slate, right? To learn from what all the other jurisdictions are doing, and to say, oh, that worked well, that didn't work well, and now in Angola and Mozambique, let's take the best for our future accreditation system. All right, so to my panelists, I was going to ask you something about your legislation. I might still do that at the end, but I'm going to leave that question for now, just because of time reasons, and jump into the question of enforcement, because particularly in light of the Singapore Convention, and this is Singapore Convention Week, enforcement of mediated settlement agreements is a really big topic. And leaving aside the Singapore Convention for a moment, or you can, insofar as your jurisdiction might have ratified, you can have certainly mention it. But I'm curious as to how mediated settlement agreements are or are likely to be enforced in your jurisdictions. And let me start with Katja.
Thank you. So in Portugal, a mediation agreement can be enforceable in two ways. Directly, so if the specific requirements that are established in Article 9 of the Mediation Act are accomplished, the agreement is directly enforceable. So if one party do not comply with the obligations or duties established in the agreement, the other party can go directly to the enforcement court and present the agreement as an enforceable title. But for that, one of the requirements is that the mediator is on the national list. So if the mediator is not in the national list, the agreement will not have that enforceable or will not be enforceable at the court. Another way to an agreement, a mediation agreement, be enforceable is through a homologation process. This is an electronic process, but both parties have to present the agreement and ask for a judge to declare that that agreement accomplishes several requirements. So the parties have to have capacity to reach the agreement. The public order cannot be violated. So there are some requirements, not much, but a few requirements. And if all the requirements are accomplished, the judge homologates the agreement, and then the parties can go to court. The only thing that I do not agree so much with this system is the homologation requirement that both parties have to ask for the homologation, because if you are already in a situation where one party do not comply with the agreement, you will not agree to go to the homologation process. But we actually have the automatic enforceable possibility of have an agreement to be enforceable. So that is quite interesting, and it is a good measure prescribed in our law.
Thank you, Katja. I think so. You described those two enforcement mechanisms for direct enforcement. In fact, they're both related to direct enforcement, not just proving a contract. But the first one's interesting because it links professionalization in the field to direct enforcement, right? And I think that's a sort of a nice piece of creative lawmaking there to also promote professionalization. We're going to go to Singapore now. Dorcas, tell us about.
I think there are some similarities with what Katya has just spoken about, actually. So there's a link between professionalization as well as enforcement. So probably two ways. First, for cases that are pending in court, that means that their cases have been filed in court, and if they then attempt mediation while the case is in court, there has a very well-established practice where the judges, by consent, they can have their mediated settlement terms recorded as a consent order, right? So then immediately becomes a court order that can be enforced. So there has been a long history of doing that. But for cases outside court, so that's where they really wanted to instill public confidence that even you don't have a case in court, and you don't want to encourage people to do mediation only when they have a case in court. So we have two ways for enforcement for those type of cases. One is the Mediation Act 2017. So this was actually passed before there were any finalization of the Singapore Convention on Mediation. So it really was for domestic matters in Singapore. And so they could actually have convert a mediated agreement, right, mediated settlement agreement into a court order. So there's a mechanism in the Mediation Act 2017 which allows parties to apply to court for that written settlement terms to be converted to an order. So there are some requirements there, but I just want to highlight that it's also linked to who the mediator is. So they do state that the mediation must be administered by a designated mediation service provider. So that's one option. The other is a certified mediator. So this practically means that actually if you're certified by SIMI, right, so then you have the benefit of having this enforcement mechanism. But besides having a SIMI mediator doing it, there are some designated mediation service providers that basically are the very well-established ones, say like Singapore Mediation Center. We even have WIPO, the Intellectual Property Office. So if it's administered by one of these providers, they also have the benefit of applying for this mechanism, can be enforced, converted to court order. That court order can be enforced in the event of any breach. And then finally, but not least, of course, is the Singapore Convention on Mediation Act, which actually is just giving rise to our obligations, having signed the Mediation Singapore Convention. So those requirements there are really for international commercial mediations. The requirements really are similar to what is currently in the Singapore Convention on Mediation, such as a signed agreement. So I won't elaborate too much on that. So I think mainly we have those three approaches.
Thanks, Dorcas. So also, I guess, similar to Portugal, a number of different ways for direct enforcement. And of course, there's always the path of enforcing via ordinary contract. And I think that's really interesting because sometimes with the focus on Singapore Convention, we forget that there are already existing many mechanisms for direct enforcement of mediated settlement agreements. I'm going to move to Brazil and then to Macau. And Nuno, you're back. Well, you've got a different background. Wonderful, wonderful. Wonderful. All right, so we'll go, if it's all right, Umberto, Bruno, and then Nuno. Yes. Over to you,
Perfect.
Umberto.
Thank you, Nadia. I think in Brazil, the situation is quite similar, although we might have a little difference. You can do it. You can enter into an agreement inside a judicial process or outside. If it is inside, you just have to present the petition of the agreement to the judge, and he's going to homologate it, as well as occurs in other country, as well as Katia said. But the difference is that you can also do it outside the judicial system. And then we have certain cases, in certain hypotheses, you can keep your agreement that way. You don't have to submit it to a judge in order to homologate it in certain specific case. For instance, in a contract between two private parties, in a contract between two people that do not have any kind of vulnerability or individual actions, or if there are not minors or underaged people involved, you can keep it outside the judicial system. In other cases, if you are transacting with a more fundamental right, if your transactions involves minors, if it is in a administrative action against, for instance, a public server that has committed a crime or a disciplinary infraction, or offended in somehow our administrative code. In that case, the agreement between the public minister, the prosecutor's office, and this guy, that should be presented to a judge in order to be supervised, in order to be homologated. So when private parties are involved, in most of the cases, you don't need to submit it to a judge. In these certain cases, you do have it. In criminal cases, you always have to submit to a judge in order to get, in order to that agreement to produce its regular and legal effects. In public civil actions, the public ministry in the first moment and the public entities, they do not have to submit the agreement, but in most of the cases they do it, so that you can get a more higher level of security so that other interested parties are going to be notified about the agreement. We don't have that specific rules like we have in the United States that you always have to submit it to a fairness hearing according to Rule 23 of their federal rules of civil procedures. But I think it's tending to be it's being a tendency here in Brazil. Thank you.
All right, thank you. So, interesting to hear sort of the different types of mediated settlement agreements and that the requirements might be a little bit different, but also that, that in some cases there is even if it's not a requirement, a tendency to try and get the mediated settlement converted into a form that allows for more direct enforcement. Yes, yeah. I think that's a worldwide sort of characteristic of lawyers wanting to be safer with the direct enforcement mechanism. Tell us about Macau, please.
Thank you, Nadia. So basically, it's also more or less the same procedure as you have in Portugal and Brazil, where you have, in general, two mechanisms, ensuring that mediated settlement agreements can be enforceable. So it's either court-related mediation procedures or outside court-mediated procedures that are carried out by specific institutions. So with the court mediation procedures, it would fall to a judge to confirm the agreement by passing a judgment that incorporates that agreement that the parties have reached. Outside the court mediation procedures, either they are the ones run by the World Trade Center or the Macau Lawyers Association mediation centers or the Consumer Rights Mediation Centers, the Medical Error Mediation Center. They all have their different provisions, but more or less all of them say the same thing, which it falls down to this entity who is appointed by this center to homologate these settlement agreements so that they can carry and can be enforceable. But hopefully in the near future, we would have something that, like Katia mentioned with the mediation law, that links also professionalization with mediation to ensure also a standard of quality and basically safeguard the rights of the parties that trust in mediation. And in a nutshell, that's how we are running enforcement in Macau.
Thank you. So similarities, as you said, to Portugal and Brazil, but also anticipation of perhaps developing some regulation linking professionalization to enforcement. And I too think that's a very important step forward and a very creative solution to link those. Nuno, can we hear you?
Yes, you can hear me. I hope so. Thank you very much. In a brief, because I think we don't have too much time. We have in Angola and Mozambique a similar procedure than you have in Portugal and in Brazil. We don't have the obligation to the agreement of the mediation agreement as be signed by the mediator accredited, like we have in Portugal. So in Angola, the mediation agreement are directly enforceable. And in Mozambique, we have a special obligation. It's the deposit of the mediation agreement to be after enforceable. So this is in a brief comment, the global framework of Mozambique and Angola.
So thank you. So if I understood you correctly, basically your mediation law does provide for direct enforcement if certain requirements are met, but then you also talked about mediation having the same effect as an arbitral award. Is that under the same law?
Yes, it's you understand correctly. The mediation agreement are directly enforceable to the court if you want. You don't need to go to a judge.
Yes, understand. Okay, well, that's interesting. And I think it is a feature of legal systems, and it makes sense to use, I guess, legal structures that you're familiar with: arbitral or consent awards, consent orders, And I know we're running out of time, so I'm going to wrap up with one last question, because it leads me to the Singapore Convention, because the Singapore Convention makes it possible for those jurisdictions that have ratified not to have to use a court order necessarily, or not to have to use an arbitral award to offer direct enforceability for mediated settlement agreements. So I've got 2 questions for each of you to answer in 1.5 minutes each. All right. So so just give me some key words. One is, where is your jurisdiction at with the Singapore Convention? Just very quickly, right? And the second one is, in your mediation legislation or your main piece, just in a couple of key words, what does it cover? Like enforcement, confidentiality, procedure, or none of the above? Right. Starting with Dorcas.
Okay, so I do have to answer the first question. So it's obvious we have signed the Singapore Convention. Our legislation covers is probably a light touch, right? So it doesn't really cover. It wants to enable mediation bill to experiment. So it really covers the basic legal infrastructure needed to support mediation, such as confidentiality, or mediation communications. Confidentiality also as coupled with inadmissibility of some of these communications for legal purposes. Yeah, so that I think that really is the main thing, and then the enforcement mechanism. Other than that, it's really we have soft law, right? Like such administered by SIMI to ensure quality. So those issues of quality are not governed by legislation. So I'll stop there.
Thank you. I'm going to go Nuno, then Bruno, then Umberto, and Katja. So Nuno, over to you. What's the main aspects of law that are covered by your Mediation Act? And tell us where you are with the Singapore Convention.
So, starting by the Singapore Convention, Angola and Mozambique and the other African Lusophone countries didn't sign the Mediation Convention until now. I think from the Lusophone countries, Brazil and Timor, it's the only ones who signed the convention. Of course, I understand. I think signing the Singapore Convention, special for countries like Angola and Mozambique, we have a lot of foreign investment. It could be very, very, very important. So I believe the government of Angola will do it soon. And I hope so. Mozambique also can do it. So for the main points of the national law in Mozambique, Angola, I think we have the same principles we have abroad. We can say the national law of these countries are based in the international laws. So the confidentiality, it's one of the main steps of the both law. I think so.
Thank you. Thank you. Great summary. Bruno, over to you.
Thank you, Nadia. So basically with the Singapore Convention, Macau is a bit special, just like Hong Kong, because China has signed it, but it needs to be extended into Macau after consultations with the local government, which have not happened yet. So we are not part of it. Although it's a bit strange for that not to happen, because mediation is something that's very, very important for the Chinese. And the way they see Macau as a platform of trade between China and the Portuguese-speaking countries, and Macau being the center of all this, and mediation would assume a key factor in facilitating resolution of disputes. So I would say soon, very soon, we should have some more news about that. In regards to legislation, I would say, although it's a bit of patchwork, again, that word, it's the same common elements, it's voluntary, and confidentiality is something that we see across all of these regulations that touch on mediation. So that would be all.
Thank you very, very much, Bruno. Humberto?
Thank you, Nadia. Brazil signed the convention in June 2021. It took a bit long to do it, but finally we did it. And I think that the key words for mediation in Brazil is voluntary, confidentiality, and a possible transaction between private and public rights, individual and collective rights, in civil and criminal matters. We are expanding a lot our spaces of consensus in Brazil at this moment. Even the Supreme Court is now ordering some audience, some hearings in order to try consensus in constitutional matters. So I think we are in a good pathway to provide good tools and opportunities for consensus in Brazil.
Thank you. It sounds exciting. We're going to come back to you all in a year at least, I know. And back to Portugal in the EU. Tell us about that, Katia.
So regarding the Singapore Convention, unfortunately, we are waiting for a European Union decision. So we are not signed it yet because it is still on decision if we sign individually each member state, or if the European Union side as a whole institution in all the member states will be mandatory, obliged by that signature. And I hopefully that they take a decision very, very, very soon, because I think it's important to European Union that we sign the Singapore Convention. Regarding the law, our Mediation Act have 4 chapters, 4 main chapters. The first chapter is about the principles of mediation. So we prescribe voluntariness, confidentiality, impartiality, independence, responsibility, competence, and enforceability of the agreements. The second chapter is about procedure. So some requirements of the stage and that the mediator have to comply with. The third chapter is about the professionalization of the mediator. So we have specific rules because we don't have a specific national code of conduct. We adopted the European Code of Conduct. So we have specific rules in the Mediation Act. And finally, the final chapter is about the public mediation systems. We also have a specific law about business recovery mediation, and each public mediation system has a specific regulation to some specific issues. So that is basically our main landscape, legally speaking. So thank you so much.
Oh, thank you. Sounds like a very comprehensive piece of legislation you have there. Ladies and gentlemen, our time is over. And I would just actually say we have one question, but it's quite a detailed question. So I'm going to just leave it in the chat and also invite our speakers after our panel to please have a look at it. And if you wish, you can respond via the chat. I'm sorry that we didn't get to it, but thank you for the question nonetheless. Ladies and gentlemen, I know we're online and I never quite know how to do this, but I want to applaud the speakers for putting up with my arbitrary order, but also for a really engaging conversation. I learned so much. Thank you so much. And thank you, Anna. Back to you.
Thank you.
Thank you very much, Nadia and all the panelists. I was saying to a friend here, you know, if they want to write an article about comparing the legislative system on these countries, this was really an insightful panel that can give the highlights on what to put in it and how to start. And thank you, Nadia, for being here with us and to arrange this a way of explaining the legal system that is much more fun and much more, I believe, for all the ones that are listening to us, much more engaging. Thank you so much for that.
My pleasure.
And we will see us, I hope, in a coffee in one of these days. And with this, we will move to panel 3, which will focus on the best practice in mediation with insights from the field. in Singapore, Brazil, and Portugal. This panel will showcase innovative approaches and strategies that are currently shaping the mediation landscape in these regions, and all of them will emphasize the role of mediation in fostering international cooperation. So I'm delighted to introduce our moderator for this panel, Liana Goldberg Valdercaro. Liana is the Vice President of ICFML Brazil, has over 25 years of experience in dispute resolutions, specializing in business matters. She is also the Vice President of the Brazilian Center for Mediation and Arbitration, CVMA, and holds several advanced certifications in mediation. And as you know already, if you want to have the full curriculum of our speakers, please go to the website that we put on the Zoom of the chat, and so you can follow up on that. Liana, we are looking forward to your guidance as we delve into these practices. So the floor is yours now.
Thank you so much, Anna. I'm so glad to be here. Thank you for your kind invitation. We have this event with great professionals, insightful information and reflection related to mediation, to Singapore Convention in different jurisdictions. And now the task to moderate this panel is related to best practices. So insights from the field, Singapore, Brazil, Portugal, we're gonna listen initiatives from private and public sector. And I first would like to introduce our first panelist, our presenter, Eunice. Eunice Chua is the Chief Executive Officer from the Singapore Financial Industry Dispute Resolution Center. So please, Eunice, the floor is yours.
Thank you so much, Liana, and hello everybody, wherever you are in the world. Today, our topic is best practices, and I know that all of us have a different perspective on it, so I'm very glad to start us off. I prepared a few slides. So first, I wanted to explain that I'm from the Financial Industry Disputes Resolution Center, and it's a center that specializes in resolving disputes between consumers and the financial institutions like banks, insurers, and so on. Can I just check whether you can see the slide? Okay, great, thank you. And FIDREC, as Dorcas mentioned earlier, is one of many institutions in Singapore that look at mediation. So this is just a visual representation for you of all these various mediation organizations in Singapore. Some of them focus on commercial disputes. Our courts offer mediation. Our law society offers mediation. We have private organizations who have set up to offer mediation, and we have industry-specific organizations, just like Dorcas mentioned. So some of them are illustrated here. Well, each organization, although there is a broadly common understanding as to how we practice mediation, but each has adapted to its unique circumstances. So I'll tell you about what FIDREC does. For us, because mediation takes place between a consumer and a financial institution, so there's always what mediators call a power imbalance, right? In that there is one party who is often thought of as weaker, less resourced, and then the financial institution, which most people think is very well resourced and has the legal backing of lawyers in their employment and so on. So at FIDREC, understanding that there is this imbalance, our model and practice is to have our mediators be full-time staff of FIDREC. So they are not a panel of mediators that, we appoint from different industries, but they are all our staff who are specially trained in financial dispute, financial regulations, and all the guidelines that our Monetary Authority of Singapore may issue. We tend to have a very flexible way of conducting mediation. So this being for consumers, it has to be very accessible. We generally start off with receiving a complaint, and this complaint can come in through email, right? But now we have channeled them towards our online claims filing form, just so that the management is more efficient. After we receive this complaint form, we will contact the financial institution for an investigation report. Once we have these two pieces of information, we then start with facilitation. So our mediator may call up the complainant to find out what his thoughts are, to share what the financial institution has reported in their investigation. They may also do this by an online meeting. And if the mediator thinks that it is worthwhile, the mediator will schedule a mediation session. So for us, this concept of mediation is not sort of strictly focused on having a session for everybody to gather together, which is what we would normally think about. But because we want to be very effective and efficient, we may close most of our mediation cases without convening a physical session, whether in person or online, but mostly by exchanges of emails, phone calls, and in this manner. So although all our team members are trained in facilitative techniques, we are also trained in some evaluative and transformative techniques. And that's because for consumer dispute resolution, the consumer may come to us and they may take many different forms. They may have different backgrounds. There may be an elderly consumer who is not very aware of their legal rights, their options, or even what financial product they have. We could also have a COO of a company come to us with a dispute, right? So the way you conduct your mediation has to take that background in mind. So facilitation purely may not work so well when your consumer has lack of information and knowledge, right? So that is why for us, rather than focusing on different models of mediation, we tend to focus on techniques. And three of the main tools that we train on are being able to acknowledge and manage emotions. Many times consumers come to us with significant financial loss. So managing emotions is very important. The second part is helping the parties communicate. Very often a consumer will feel very upset and hard done by because they feel that they can't reach a human being at the financial institution. They may get an email and they feel the email is very cold and technical and standard, right? So we do a lot to try and bridge the communication. And finally, and this is not very typical for mediators, we may make suggestions where parties are not able to generate any options on their own, or they are stuck at an impasse, right? And we do this bearing in mind our experience in terms of similar cases in the past, our knowledge of what that particular financial institution is able to do. And so we bring that experience to bear on the mediations. But overall, as Dorcas mentioned, in Singapore, we very much are focused on being professional in the ways we conduct our mediation. And at FIDREC, we also commit to following the CIMI competency standards. And so, as Dorcas mentioned, CIMI is our International Mediation Institute in Singapore that sets the standards for mediators and mediation. So this slide just summarizes for you, what our mediators must be able to do in terms of managing process, managing relationships, and also the content of the mediation, as CIMI calls it. So this is a quick overview for you of what we do, and I'll hand it back to Liana so we can hear from others. Thank you.
Thank you so much, Eunice. quite interesting to listen. You mentioned that your dispute resolution center is focused on a specific field, on a specific area of disputes between consumers and financial institutes. So does it mean that there is a big demand for mediation, or is enough demand in Singapore related to that you have a whole center focus on that? For me, it's quite impressive. So
yes, I think
you
it
can
has to
address that.
do, yeah, thank you. It has to do with Singapore being a financial hub and a financial center, I think. So there are plenty of cases. When I first joined FIDREC about 5.5 years ago, we averaged about 1,000 claims every year. In the last 2 years, this has gone up rapidly. So it has gone up 2 years ago to about 2,000 cases. And just last year, it has gone up to almost 3,000 cases. So there is a big demand here in Singapore.
Thank you so much. And even having this large number to manage, you deal with emotions and in different consumers profiles, and really interesting to understand how it works. And now I turn to Brazil. I turn to Nicola, and I present Nicola Curi. He is Secretary of External Control for Consensual Solution and Conflict Prevention in Brazil for the Brazilian Federal Court of Accounts. And he is running this special conflict prevention. SESEX Consenso is the name of the area. Nicola will be speaking in Portuguese. So please, for those who wish to listen to English, follow the instructions provided in the Zoom chat to access the translation. So please, Nicola, we are delighted to listen your insights related to these public initiatives.
Bom dia a todos. Conseguem me ouvir bem? Liana, obrigado pelo convite. Bom, eu compartilhei uma tela só para guiar a fala, mas antes disso eu queria agradecer muitíssimo ao ICFML, parabenizar pelo evento, mas mais do que isso, agradecer ao ICFML pela parceria nessa jornada que tem sido a criação e a estruturação de uma secretaria que trabalha de uma forma diferente da tradicional, né, do tradicional litígio que não só o Brasil, mas que muitos países experimentam. Então, mudar a cultura da própria casa, mudar a forma de fazer as coisas tem sido um desafio bastante grande. E o ICFML foi nosso parceiro de primeira ordem desde o primeiro momento, nos ajudando aí a entender esse mundo da mediação. E estou aqui hoje aprendendo mais com essa aula aí de como as coisas acontecem em tantos países. Então, um agradecimento especial à Ana Maria e à Kátia, que estiveram conosco em tantas agendas aí. Tivemos a oportunidade de certificar já 20 dos nossos auditores, então tem sido uma experiência e por isso destaco esse agradecimento. Bom, eu trabalho no Tribunal de Contas da União, que é a nossa Corte de Contas no Brasil, na área federal, e o Tribunal de Contas da União ele tem como missão contribuir com o aprimoramento da administração pública no Brasil. E o Tribunal busca exercer essa missão através principalmente de auditorias financeiras, auditorias de conformidade, auditorias operacionais. E o tribunal no Brasil ele tem a possibilidade de fazer determinações corretivas quando os atos praticados pelos gestores não estão aderentes à norma, e também de sancionar gestores que pratiquem atos fora do que a norma prevê. Então, eu queria comentar isso mais como contexto de como funciona a Corte de Contas no Brasil. Então, buscando exercer essa missão de contribuir com o aprimoramento da administração pública, o tribunal ele tem várias ações, várias iniciativas, muitas delas olhando para o que já foi feito, né? Fazendo a comparação com a área médica, muitas vezes o problema é uma exumação de cadáver, é um problema que já aconteceu há algum tempo atrás, e muitas vezes, por exemplo, recuperar os ativos de algo que já foi materializado é um desafio muito grande. Então, o tribunal vem investindo muito em trabalhos concomitantes, trabalhos mais próximos do problema, né, da ocorrência do problema. Com isso, por exemplo, o tribunal tem atuado em grandes temas como desestatizações, o tribunal tem atuado de modo concomitante à tomada ali de decisão dessa política pública. Também na área de pessoal, o tribunal tem feito uma série de trabalhos na folha de pagamento, trabalhos ali rotineiros, usando muitas vezes ferramentas de TI, e também, por exemplo, na área de licitações, em que o tribunal faz uma análise usando uma ferramenta chamada Alice, que faz análise de licitações e contratações, e aponta possíveis problemas, percebendo que essa atuação concomitante agrega mais valor para a sociedade e contribui de modo mais efetivo para o aprimoramento da administração. O tribunal criou essa secretaria que trabalha com algo muito próximo do que a gente discutiu aqui hoje ao longo desse dia, que é um trabalho de mediação. Então, o tribunal aprovou uma norma no final de 2022 que busca fazer com que não seja dado mais peso ao que não deve ter mais peso. Muitas vezes, na tomada de decisão, um gestor sozinho acaba tomando uma decisão que não necessariamente é a que melhor atende ao interesse público, mas sim é a que ele tem conforto de tomar, sem se colocar em risco, sem assumir um risco excessivo. E aí a ideia desse trabalho do tribunal é dar o peso adequado a cada questão, a cada norma, a cada necessidade que a administração pública e a população têm, o foco no poder do coletivo. Então, o tribunal exerce um papel de mediação técnica, a SESEX Consenso, que é a secretaria que a Liana comentou, que hoje eu estou responsável pelo tribunal, exerce um papel de mediação técnica, os nossos auditores certificados pelo ICFML, como eu comentei, exercem esse papel de mediadores, e nós temos um regramento que muda completamente a ótica de trabalho do tribunal. Ao invés do tribunal escolher objetos para ir fiscalizar, para ir auditar, a questão da voluntariedade, que foi muito dita em painéis anteriores, faz com que o gestor requeira ao tribunal, o gestor solicita ao tribunal a constituição de uma comissão nessa etapa de admissibilidade, nessa etapa inicial de requerimento, desculpe. Então, o gestor solicita a atuação do tribunal, dizendo que o problema que ele está enfrentando é de alta complexidade, alta relevância para a sociedade. A partir daí, o tribunal analisa se, de fato, esse tema faz sentido alocar auditores, alocar energia, ter uma atuação eficiente do próprio tribunal para discutir esse problema, né? E o processo sendo admitido, é constituída uma comissão de solução consensual. Essa comissão é coordenada pelo tribunal, mas ela tem a participação, logicamente não poderia ser diferente, das partes. O tribunal atua como interveniente, não como parte. Com isso, o ministério responsável pelo tema, a agência reguladora responsável pelo tema, e a empresa contratada, se for um problema contratual, participam dessa comissão, que tem prazos bastante desafiadores. O prazo é de 90 dias para que essa comissão encontre a solução, podendo ser prorrogado no máximo por 30. E a partir daí, caso haja uma solução para esse problema, eu costumo fazer uma analogia com escape room. Eu brinco que nós trancamos numa sala por 90 dias os grandes especialistas no tema do Ministério, da agência, da empresa e do TCU, para em 90 dias, prorrogável por 30, buscar a construção da solução. O reloginho vai contando, né? Acabando o tempo. E, havendo solução, havendo uma proposta de solução, a autoridade competente de cada uma dessas entidades vai aprovar essa proposta de solução e ela vai ser submetida à homologação do plenário do Tribunal de Contas da União, que é uma homologação na condição de interveniente, mas dando segurança jurídica a essa tomada de decisão por algo que é fronteira da administração, para que o gestor tome a decisão com essa segurança jurídica. Para vocês terem uma noção, hoje nós temos algo em torno de 250 bilhões de reais, equivalente a 50 bilhões de dólares, mais ou menos, em discussão, em processos da área de rodovias, ferrovias, aeroportos. Temos, inclusive, um processo que tem o aeroporto do Galeão, que a Changi, que é de Singapura, é líder desse contrato e está participando ativamente conosco da discussão. Então, temos aí vários temas sendo discutidos. Para concluir, eu queria só dar um exemplo. Como eu falei do escape room e do reloginho, eu sei que o meu reloginho está contando também, mas só para não deixar de dar um exemplo concreto, nós tivemos no ano passado, que foi o primeiro ano de criação da secretaria, nós tivemos benefícios bastante significativos para a sociedade. E só para exemplificar, no setor elétrico, que foram apenas 2 processos homologados, haviam vários contratos em que a energia estava sendo gerada por meio de termoelétricas, queimando gás para produzir a energia, e essas termoelétricas foram contratadas no momento em que não tinha disponibilidade hídrica para gerar energia hidroelétrica. O Brasil tem uma condição bastante privilegiada para gerar energia hidroelétrica, uma energia mais limpa do que a termoelétrica, e, na ocasião, muito mais barato. O contrato foi feito num cenário de escassez severa hídrica. Cada vez mais nós temos experimentado momentos mais críticos de clima, tanto para um lado quanto para o outro. Então, passamos por uma grande seca, e aí não tinha disponibilidade, ia ter uma crise energética, por isso as termoelétricas foram contratadas. Logo depois que elas foram contratadas, para em 6 meses começar a geração de energia, a gente passou por um outro extremo, muita chuva, passou a ter fartura de disponibilidade hídrica, e apesar dos contratos estarem celebrados e queimando gás para gerar energia mais cara e mais poluente, nós não precisávamos mais dessa energia, mas os contratos tinham previsão da energia ser gerada o tempo inteiro por termoelétrica. Com isso, foram montadas algumas comissões, as empresas foram convidadas, e foi estruturado um modelo de debate que criasse uma solução mediada entre o contratante e a contratada, e o resultado final foi que em apenas 2 processos houve o entendimento das partes homologado pelo TCU, e houve um benefício superior a 3 bilhões de reais, superior a 500 milhões de dólares, de redução da conta de energia em função de uma pactuação de revisão do contrato com a convergência das partes. Então, eu queria encerrar com esse exemplo, enaltecendo o quanto o poder do coletivo faz a diferença. Tem sido um grande aprendizado para nós no Tribunal de Contas, e nós temos discutido como aprimorar a norma. A gente sabe que ainda é uma secretaria nova e tem oportunidades de melhoria, inclusive com o aprendizado que tivemos com o ICFML ao longo da jornada da certificação, e ficamos felizes de, com 1 ano e meio de existência, né, da secretaria, temos a oportunidade de falar um pouquinho de bons resultados e boas práticas, e acaba sendo uma grande realização para nós. Muito obrigado.
Thank you so much, Nicola. Thank you for sharing with us how it works in the real world, as I mentioned. And I like it so much, your metaphor related to the escape room. So this represent exactly how it works. Now I'm going to shift also to Portuguese just to make sure I am addressing to Nicola. Nicola, obrigado, e muito bacana dividir conosco como funciona no mundo real, né? É vida real, é o público e o privado se encontrando. E aí, quando eu escuto todas essas iniciativas e esse movimento da Acessex Consenso, é bacana de ver como que o setor público saiu daquela postura quase que imutável, ou aquela considerada cláusula pétrea, né, da ideia da impossibilidade da transação do interesse público. Você trouxe aqui mostrando como que dá para fazer, e justamente o contrário, preservar o interesse público é transacionar. E a gente tinha justamente uma ideia oposta, e você está trazendo que dá para fazer. É essencial a gente ouvir cada vez mais essas iniciativas e essas experiências. Não sei se você tem mais algum comentário sobre isso, antes da gente passar para o Daniel Rainey.
Só reforçando, Liana, o tribunal, de fato, ao longo do tempo, passou por uma mudança de visão dos próprios métodos adequados, alternativos de solução de controvérsias, e acho que isso é reflexo dos próprios bons resultados que os métodos vêm conseguindo entregar. E, com isso, ao longo do tempo, vários riscos vão sendo mitigados. No Brasil, a arbitragem cresceu muito, e acho que cresceu muito, talvez até mais do que a mediação no primeiro momento, pela nossa cultura de litígio. Procuramos brigar de um jeito melhor e não deixar de brigar. E acho que agora está mais claro que deixar de brigar talvez agregue ainda mais valor do que brigar de uma forma melhor. Então é nisso que nós estamos apostando. Muito obrigado mais uma vez.
Obrigada, Nicola. Thank you so much. Now I turn to Daniel Rainey. So please welcome Daniel. He is a principal in the firm of Holistic Solutions, a fellow of the National Center for Technology and Dispute Resolution, and vice president of the International Council for Online Dispute Resolution. And here he's representing the Alliance of Mediators for the Universal Disclosure Protocol for Mediation. Please, Daniel, join us with your insights.
Thank you very much for the invitation to be here. I appreciate it. Can you hear me okay?
Yes.
Very good. So unfortunately, I didn't do any slides. I'm sort of old-fashioned that way. I sort of like to talk to you directly. And what I've been asked to talk about today is the Universal Disclosure Protocol for Mediation. And I want to do a little background on what it is and why it is and why I think it's important. If you look at some of the academic studies of mediation around the world, one of the consensus issues is that there are many, many ways to do mediation. In one case, they're citing at least 50 different modes of mediation that occur on a regular basis around the world. And there's some similarities, but there are some significant differences. Differences in the perception of the role of the mediator, the perception of how aggressive the mediator should be in making suggestions, the confidentiality that you can provide for the participants. So there are many, many ways to approach mediation around the world. And what that does is it means that if I'm a mediator, which I am and have been for many years, I bring a bias about how the process should run because of my training and my background and my experience. So I'm going to enter the mediation with the parties, having an idea of how I'm going to do that mediation that is comfortable for me, that I recognize and understand from my training and my experience. Unfortunately, the parties also enter that mediation with a set of expectations. The parties may come into that mediation with having done mediation before. So their assumption may be that the mediation that I'm going to do is going to look exactly like the mediation that was done before with them. And that may or may not be true. You also may have parties who come into mediation who have never been in mediation before and have really no idea what mediation is, or may have an idea from some outside source that is not exactly consistent with the approach that you might take as a third party. So there is, because of this, the large number of ways that mediation can be done, and because of the expectations that we bring to the mediation process, both as the third party and as the parties, there is a pretty good possibility of misunderstanding. And my partner and my wife, one of her favorite sayings is that much of the conflict that we deal with as mediators is brought on by the violation of expectations. And many times we don't know what those expectations are overtly until they're violated, because they just are part of us. So why have a universal disclosure protocol? One of the things that you can say about mediation is that almost nothing is universal in the way we do mediation, but as close as you get to universal would be the idea of self-determination, that the parties choose to enter the process and that they can choose to make a resolution or not make a resolution. And it's tempting for us to think about self-determination from the back end. That is, at the point at which the parties are able to say, yes, I will agree to do that, or no, I will not agree to do that. But self-determination actually begins at the very start of the mediation process when the parties say to us, yes, I will join you in that process. What we think, and one of the reasons that we were driven to try to create the Universal Disclosure Protocol is we want to be sure that when the parties say, yes, I will join you in that process, they know what they're saying yes to, and that they agree to the process, because that is part of self-determination as well. And so what did we do? Anna Maria and I began talking about this quite some time ago, and we put together a working group of professional mediators from every continent except Antarctica. And basically what we said was, if you were going to start a mediation with full disclosure so that the parties would say yes and understand what they're saying yes to, and would be exercising pure self-determination, what would you include? What would you talk to them about before you started the mediation to make sure they understood what was going to happen? And through a series of discussions and a series of editing processes, we came up with 6 things that we think are the keys that should be discussed by any mediator before they start a mediation with parties who are before them. Conflict of interest. What does that mean in the place where you're doing the mediation? What can you guarantee in terms of conflict of interest? There are differences in legal protections. There are also differences in the way we handle material. So what do we say to you about the conflict of interest? Confidentiality. What is the extent that we can promise absolute confidentiality in the work that we're doing? What is the general process I'm going to use? Am I going to be facilitated? Am I going to be directed? And do you know what those words mean? Do you know what that says about how I'm going to behave? What is the role that you expect of me? And what is the role that I expect of you as parties? What's the technology that I'm going to use? And what effect does the technology have on our process? One of the things that I do on a routine basis is talk about a risk damage assessment for the use of technology. If the parties I'm dealing with are dealing with information that is very secure and very sensitive, it would harm them if it were accidentally disclosed. We talk about the risk of disclosure for the type of technology that we're going to use and how to mitigate the damage. So we may choose never to use email because it's easily misused. We may choose never to do any technology because we want to keep it in hard copy. But we talk about that as part of our process. And finally, the impact of venue. Where am I doing this mediation? Where are the parties and where is the mediator? And what is the impact that venue that we're operating in have on the way I would conduct the mediation and what I can promise? So you put all of those together and the mediator comes in presenting from his or her point of view what normal looks like for the mediation they're going to do. You discuss those things with the parties, those 6 things, and the parties say, yes, I understand that, I agree, let's go forward. That's wonderful. If they say, I don't really understand that, and maybe I have a problem with that, then you need to talk about that before you begin the mediation process. So that in a nutshell, I'll try to wrap up very quickly here. That in a nutshell is what the Universal Disclosure Protocol for Mediation is. If you go to udpm.org, you'll see the website has a full explanation of all of the elements. And essentially, what we're trying to do with the Universal Disclosure Protocol is to say, look, when parties enter mediation, they want a good experience. And part of that good experience is feeling like they have some control over their lives. And if we can use the UDPM as a way to normalize and create a safe environment for the parties as they come into mediation, the mediation will work better, the parties will be happier, and everybody's interests will be served. So I'll wrap it up there.
Thank you, Daniel. Thank you so much. And by the way, for those who want, the protocol is at this chat, and just helped us to cover the protocol over the chat. You mentioned expectations. This is so important for the parties, for the mediation. And just a quick question, would you consider the mediation trainings will help address these expectations if the trainings are better, or if you focus the training understanding this reality of the expectations will help even better and joining the protocol? How would you consider the trainings would help this to develop?
Yeah, what a very good question. There is a good side to training and there's a bad side to training. The good side to training is if you come to mediation with no experience, you have to have some guidelines. You have to have some parameters in which you operate. And so every training that I know of, and I've done a lot of training and I've been involved in a lot of training, will set out a series of expectations for how the mediator should behave that may be different in different locations. In some places, it may be more directive. In some places, it may be more facilitated. But there will be in the training that you get an embedded set of biases about how you should conduct yourself as a mediator. And that's terrific, because if you don't have that, then you're all over the place, you have no system, and things are not going to work very well. The downside of that is that you're building in those expectations. And there are so many ways that are appropriate to do mediation that one set of trainings that trains you to do something very well in one way may not work in another situation. And so what I advocate as a trainer is to to put out the guidelines, to set the limits and say, this is what we do as mediators, but then to say, okay, be aware that there are other ethical ways to behave as well. And sometimes you have to flex as a mediator into those other ethical ways to behave in order to make the parties feel that they're comfortable and secure. And so what I advocate in terms of training is, yes, do the basic training wherever you are, but be mindful that the assumptions that you make, the things that you bring with you out of that training may not always be effective, and you may have to flex.
Thank you so much. This mediator self-conscious is very important.
Exactly. Know
So
that,
now,
actually, that is that's the motto of my company, is know thyself first.
oh, that's great. So we are now going to see a video about the protocol. Please, the video.
The Universal Disclosure Protocol for Mediation, the UDPM, is a set of topics designed to provide a framework for mediation so that all parties and the mediator have a congruent understanding of their particular mediation process and can fully exercise self-determination by choosing to enter the mediation process.
The elements of the DPM are conflict of interest, confidentiality, general process, role of mediator and the parties, technology, impact of venue.
A UPM foi criada como uma resposta à ampla variedade de estilos de mediação como modo de mitigação e prevenção de possíveis confusões no âmbito do procedimento de mediação.
调解的通用披露协议 The Universal Disclosure Protocol for Mediation 让我作为调解的使用者知道我在文化、宗教、法律制度或国家的调解中可以期待什么。也因为这个协议，我可以充分了解情况，并完全尊重自我决定的原则。
As a mediator, the Universal Disclosure Protocol for Mediation, UDPM, gives me a practical tool to follow and define the disclosure elements to be used. Anywhere in the world, as mediators, we can adopt this simple protocol independently of the mediation mode we practice. Importantly, it gives a simple message to users about what to expect from a mediation.
When I serve as a lawyer in a mediation, I need to know what the mediator is going to do in each case, especially in an international dispute. Mediators are trained differently around the world, and the UDPM gives me greater transparency and certainty regarding how my client's case will be handled. It allows the disputants to design their own process, and especially to discuss and to bridge cultural differences in approaches to mediation. Another advantage is that it creates greater trust, not only in the mediator and between the parties, but even between me and my client. I prefer to work with mediators who have endorsed the UDPM concept.
The UDPM is offering the mediation market an electronic badge that can be used by all mediators, lawyers, mediation organizations, and other organizations that adhere to this initiative. Mediators who endorse this protocol will be easily identifiable as such, as will be the lawyers who prefer to work with endorsing mediators.
To endorse the UDPM, go to www.udpm.org. All the mediation stakeholders thank you.
So now we go back to our panel, and I will invite Joana Jerônimo Soares Correia. She is the chairman of the board of directors of Arbitrare, the Portuguese Arbitration Center for Industrial Property, Domain Names, Trade Names, and Corporate Names since 2012. She is a lawyer and a mediator. Please, Joana, join us.
Hello, Liana. Thank you very much. Good afternoon, good night.
I'm going to share my presentation. Is my presentation in full screen?
Yes.
Yes, just a moment. I must change here. I'm sorry. So here is it. So first of all, I would like to congratulate ICFML for the organization of such an important conference, and of course to thank Ana Maria Maia Gonçalves for the invitation to take part in this third panel. It is a real honor to be here today. So I will be speaking about arbitration as a precursor to mediation and vice versa. And in this context, firstly, I intend to present Arbitrare, what it is and its competence, and then to explain how we offer mediation services in the context of an arbitral proceedings. Thirdly, I will address our practice using statistical data in order to draw conclusions that are relevant to find out if arbitration has been an effective precursor to mediation. Then I will share with you some changes recently approved in our arbitration center concerning mediation services. And finally, I will analyze the opposite scenario, that is, whether mediation can be or not a precursor to arbitration. So, Arbitrare is a Portuguese nationalized arbitration center created in 2009 as a non-profit private association with national jurisdiction and is a part of the network of Portuguese arbitration centers. Arbitrare has 4 governing bodies: the General Meeting, with 9 associates representing the most important sectors of the Portuguese economy, the Board of Directors, of which I am the chairman, a supervisory board, and a board of regents. Arbitrare is present on the web on www.arbitrare.pt, but also on social networks such as Facebook, Instagram, LinkedIn, and Twitter. Arbitrare is competent to resolve disputes concerning economic interests regarding industrial property, .pt domain names and trade names and corporate names, provided that the disputes are not submitted exclusively to a state court or to compulsory arbitration by a special law. So, how do we offer mediation services in the context of arbitral proceedings? Arbitral proceedings filed with Arbitrare have 3 different stages. And the first stage is the presentation of procedural documents by the parties, as listed on the slide, through our online platform for dispute resolution, in-house developed. The second stage is mediation. And this stage is prior to the constitution of the arbitral tribunal. The parties are invited to a mediation session, and this stage will only take place if all the parties accept to refer the dispute to mediation. This is why we say it is an optional stage. If the mediation stage does not take place because the parties refuse to accept it, or the mediation procedure does not result in settlement, then we have the third stage, arbitration. At this stage, once the arbitral tribunal is constituted, the arbitral award shall be made within 3 months. And according to the Portuguese law on voluntary arbitration, the arbitral award has the same value, has the same binding effect on the parties, has a court judgment, and may be enforced as such. So, has arbitration been a precursor to mediation? In 15 years of activity, so from 2009 until 2023, 461 arbitral proceedings were filed, 164 arbitral awards were made, and only 5 mediation settlement agreements were reached within 9 mediation sessions. So until 2014, we thought that the reduced number of mediations in our center was due to the fact that the majority of the proceedings submitted to arbitrare involved three different Portuguese registration bodies, one of which the Portuguese office responsible for the registration of industrial property rights, which decisions are subject to arbitral appeal with arbitrare and does include the optional mediation stage. Nevertheless, these registration bodies have never accepted to resolve disputes in the mediation stage, alleging that the public interest pursuing their decisions could not be mediated. However, in 2012, the type of proceedings filed with arbitrare changed completely due to the liberalization of .pt domain names registration rules, and we began to have more arbitral proceedings between private parties concerning, of course, .pt domain names disputes instead of proceedings involving the Portuguese registration bodies. But despite this event, this data show us that when a party decides to initiate an arbitration proceedings, its goal is to resolve the dispute with an arbitral award, having very little openness to consider the resolution of the dispute through mediation. And this happened despite of the advantages offered by our center when the parties opt to resolve the dispute through mediation. Lower costs due to the fact that if the dispute is resolved through mediation, the procedural costs are reduced by 30%. Faster resolution, the mediation stage shall not take longer than 30 days, counting from the receipt of the file by the mediator. Enforceability, as you already know, because Professora Katia told us, the mediation settlement agreement is enforceable without need for judicial homologation if certain legal requirements, of course, are met. And finally, we offer an online platform for dispute resolution where the parties may choose the mediator and follow the procedure easily. So, considering our experience up to this date, we can clearly conclude that arbitration has not been a precursor to mediation. Considering our figures and knowing the advantages offered by mediation, we decided to start offering mediation services out of the arbitration context last summer. Not because we had a demand for mediation within our areas of competence, as I mentioned previously, but rather to the belief that when parties decide to resolve a dispute through arbitration, their mindset will not change to mediation. Unfortunately, since we launched this new service, we still haven't had any mediations. I also would like to point out a requirement arbitrare recently made to the Portuguese Ministry of Justice, requesting the extension of center's competence to a new area, copyright and related rights. We believe, and of course also hope, that mediation will be a great asset to resolve disputes related to copyright issues. So, will mediation be a precursor to arbitration? We anticipate to have more parties opting to resort to mediation instead of arbitration by offering mediation out of the context of arbitration, and when the parties are unable to resolve their dispute through mediation, and only then they will opt to resort to arbitration. But unfortunately, I don't have a crystal ball, so we will have to talk again in a couple of years, so I can give you an overview of our statistics and confirm if mediation has in fact turned out to be an effective precursor to arbitration. It is my understanding that with the new possible area of competence, so copyright and related rights, we will have more mediations. It is a matter of time, but also, this is very important in Portugal, of further promotion of mediation as a means of dispute resolution in the field of intellectual property. So let's wait and see. Thank you very much for your attention.
Thank you, Joana. Thank you so much for explaining to us how it works, arbitrari. And by the way, not only arbitrari, but for those ones who would like to understand how it works, arbitrari and the TCU, Brazilian Federal Court, and also the Singapore Financial Industry Dispute Resolution Center. We've got some information on the chat and the links for this specific dispute resolution for each one. So Joana, you mentioned the interactions between arbitration and mediation and the way to encourage the use of mediation. Would you believe is needed more to be done for this encourage for using mediation?
Yes, I think that we need to have lawyers proposing to their clients to go to mediation. I think we must change the law too in Portugal. I don't know if promotion of mediation is enough. I think that our numbers show us that it's very difficult to have mediations in Portugal, and this is not only a problem of arbitrare. So I really think that it's not only changing our competence, it's also we must have more promotion and some changes in our legal system, I think.
Thank
you very much,
so much,
Liana, for your question.
Thank you, Joana. So now I turn to Filipa. Filipa Cansado de Carvalho, and she is representing the Commercial Arbitration Center, Portuguese Chamber of Commerce and Industry. Please, Filipa.
Thank you very much, Liana. Good morning and good afternoon and evening to everyone. And I would obviously first like to start by thanking Ana Gonçalves and Katia Svola and ICFML for allowing me to be part of this very interesting conversation about mediation, and to also thank them for all they do for promoting mediation in the Lusophone world. I was asked to share with you some initiatives that the Lisbon Arbitration Center, CAC, which is Portugal's oldest commercial arbitration center, is undertaking to promote the use of commercial mediation, not only in Portugal, but also in the Lusophone world, with two main goals. One, increase the recourse to mediation, and second, to ensure that mediation is conducted in line with best practices. So we have heard from previous speakers that mediation is still quite nascent in Portugal, and this applies particularly to commercial mediation. Conversely, arbitration is quite popular in Portugal and has been for the last 30 years. And so institutions involved in dispute resolution, such as the CAC, had traditionally focused on arbitration. So as of more or less 2011, CAC started paying some attention to mediation. It organized, together with ICFML, 2 courses of certification of mediators. It produced mediation rules in 2016, which were then revised in 2021. But arbitration still remained pretty much the primary focus of the center. Then a new board started functions in 2022, and this board has taken further steps towards the promotion of mediation and about making mediation a focus of the center's activity. So they have a strategic plan for their mandate, where mediation finally receives stop billing alongside arbitration. So it's not just arbitration and all the other ADR, but arbitration, mediation, and other ADR. And they have, to assist them in their goal of promoting mediation and quality mediation within the Portuguese-speaking world, they have set out a specially dedicated committee regarding mediation, which is tasked to promoting mediation activities. And this is composed of several mediation enthusiasts, which are mostly lawyers and also alumni of the previous courses that the CAC had organized with ICFML. And in line with the best practices in mediation regarding disclosure, I should disclose that I am the chair of that committee. So you take that into consideration when I talk to you about the activities that we have put together. So in our first meetings, we have tried to identify why is it, and this is a question that we've seen this from the past panels, that this disturbs all of us. Why is it that mediation works, but is still so underused in the jurisdictions that we are talking about? And this is not an exhaustive diagnosis of the problem of mediation, but we did pinpoint some things. Lawyers and parties do not know about mediation, or sometimes worse, they think they know, but they don't know. So they have all these misconceptions about what mediation is. Then there is a problem of lawyers being very risk averse, and they do not want to propose to their clients something that they fear their clients might ultimately be disappointed with. This ties in with the lack of knowledge about mediation. And conversely, they think there is no risk for them of not proposing mediation to their clients. And there's also, we feel, a lack of discussion of success stories about mediation. So one of the keys to the success to mediation is that confidentiality really works. People that are involved in mediation know that mediators, lawyers, parties take this seriously. But then this somehow, it did not have to, but it makes it more difficult to discuss success stories. And that is very important, so that people know that mediation actually works. So we took all of this together, and we concluded that to promote mediation, we needed first to demystify common misconceptions about mediation. We had to gain more allies, both in the council world and in the in-house world. And we had to show to the public that mediation works. It's a little bit like Caesar's wife. It has to work, and it has to be seen to be working. So we put together some things, and I'm going to briefly talk about them, not in a chronological order, because this is also a trial and error thing, but starting with the simplest ones that we put together. And the first 2 things that we put together that are actually quite simple, all of them are not rocket science, actually. The first 2 things have a little bit to do with the success story of arbitration in Portugal. So we concluded that arbitration became quite popular, not only because it was, in fact, a good alternative to the existing dispute resolution services, but also because there was a notion that, right or wrong, that law firms at the forefront of dispute resolution were using arbitration, and human beings are human beings, so they do not like to feel excluded. They want to be a part of what's going on. And so what we did was that we proposed to the board of the CAC that the annual conference had to have a slot, at least one, about mediation, and it had to be a practical slot, and not that worst slot that you fill in and that people are not going to arrive at that hour to see it, or in the last slot where people go home to get dressed for the cocktail or whatever. It had to be a good slot to signal that this is important, we care about this, this is a star topic. And we took a lot of care in putting this panel together with counsel, external counsel, in a party, in this case an in-house counsel, and a very good mediator, so that they would talk about success stories. And the panel was, luckily for us, also I think a success story from all the feedback that we got. And we also tried to get a conversation going about mediation, an ongoing conversation about mediation. And we do this. Someone was saying, I think Dr. Lydia was talking about that we work together jointly, and also Joana Correia just now, that this is an effort, a joint effort. So the benefit of being a tight-knit community is that we get to know what each other, what the others are doing, the other organization, the other people that believe, that know that mediation works. And so we try to have an ongoing conversation about mediation on social media and with conferences that do not overlap, so that there is an idea that there are talks about mediation during the entire year. We also organized, together with ICFML, a new course for mediation certificate for lawyers, because it's not just about increasing mediation, but it is about having good quality mediation. That is very important. And I have to tell you, the first time we put the course together, we completely flopped. We did not have enough people that registered to get the course going. We were, of course, frustrated and disappointed. And to use mediation jargon, we concluded that perhaps the market was not sufficient mature for the course yet. And perhaps the course was also not mature. We had to engage into a conversation. We wanted to have lawyers. So we also spoke about lawyers, about their interest, and about how, and I don't have time to go into this in detail, but why we think that it's not true that there is no risk for lawyers not to propose mediation to their clients. So we engage them in a conversation. We created this momentum about this continuous conversation about mediation. We also rebranded the course a little bit, so because people think I'm not going to have work as mediator right now, so why should I have a certification as mediator? So we rebranded it as an intensive mediation course that would teach lawyers on how to use their skills in favor of their clients, with the added bonus that it will give them a certification as mediator. So surprise, surprise, the course was a success. We had a waiting list. People have asked us, when are we going to do another one? So we are very happy about that. And finally, and this was perhaps our most ambitious project, we created a temporary free mediation services offer. And I know that I've passed my time, but if I may have some extra minutes to briefly talk about this, because we know that we wanted two things with this offer. So the offer, the CAC and the mediators offer to the parties a mediation up to the first session with the mediator. So a first morning and a first afternoon. And then if the parties want to continue with the mediation, they can, and then they pay the usual fees that they would pay in a normal mediation according to CAC. And what we wanted to this, we had two goals. One was, again, to get the conversation about mediation going. We produced a lot of materials about mediation, facts and things, and we created an email where you can ask questions about mediation. And that part, I think, was a goal that we accomplished. And I think this was important also in the success of the second time that we launched the mediator course. And the second goal, which was not a success yet, but this is again like mediation. We did not reach an agreement on the day, but perhaps the agreement is forthcoming at any time soon when we again launch the program. We wanted people, we know that mediation has a high rate of satisfaction with users, even when an agreement is not reached. So we wanted people to experience mediation with diminishing their risk, which here essentially was a cost risk, so that they would see how mediation is in practice. And we knew that this was quite risky. We knew that the market is very conservative, and we had to have at least 4 people on board for this to take off. So two clients plus their lawyers. So we were not surprised that the first time we launched this, there were no people taking our offer, but there was a lot of questions. And after we had closed the first time that we offered the program and we had done the course, people asked, are you going to do this again? Because I'm quite interested and I would like to try. So I hope that perhaps next year or somewhere else, I don't have a crystal ball like Joanna, but I hope that next time that we speak about this, I will be talking to you about how we launched this offer again with some different results. So thank you very much.
Thank you, Filipa. Wow, great to listen so many initiatives and different ways to approach mediation, to offer mediation for clients, and so good to listen that. And it's quite interesting because I keep thinking myself, since I started the study of mediation, we listen a lot the step clauses, the med-arb clauses. But so far, I've been listening that is working arb-med. So after being in an arbitration, people already file arbitration. They are already litigating, but they now have more information about the claims. They know the counterparty claims. Maybe they know the counterparty even documents. They already have the evidence. So even being litigating, why not consider mediating? So this is starting to change here in Brazil. I can say this way. We call that mediation window. So is quite working arb-med, maybe more than med-arb. Med-arb, they are not mature to try mediation before, but after the process of living in arbitration, the emotional and the time framing, all the aspects we already know, they consider more arb-med than med-arb. So quite interesting to listen to you. But now we turn now to Josephine, and I apologize up front if I mispronounced. Is Josephine Hadiksumu, and she is representing Alliance for Mediation Standards at the Asian Mediation Center. So please, Josephine, join us.
Thank you, Liana, and good evening, good morning, good day to everyone who is present today. My special thanks to Anna Maria for this invitation to be in this wonderful program, and also extra special thanks to Liana for moderating this panel so ably to date. Now, I understand we are running quite a bit behind time, so I will try to keep my remarks short and to the point and leave some room for questions later. I hope that's okay with everyone. Now, we have had wonderful slides today in this panel, and we have even had a wonderful video. I don't have a video or slides for you, so I will tell you a story. But before I tell you a story, I will give you a little bit of a background for me. As Liana mentions, I am the director for the Asia Mediation Center, which is a center based in Malaysia. But I also wear a separate hat, which is as a board member on the board of directors for the Singapore International Mediation Institute. Malaysia and Singapore are quite close in terms of being neighbors and in terms of our development and our history. So I find it quite interesting to have both perspectives, and I'm able to bring both to the panel today. I would like to draw your attention firstly to Eunice's slide. If you remember, one of Eunice's slide, as her first one, I think, showed the different types of mediation centers and institutions within Singapore. And I'm sure many of you were wondering, there are so many in Singapore. Now, try to picture this many institutions, but across different states and different countries, all around the region and beyond. And this is the reality of what we are dealing with today. There is a proliferation of mediation and arbitration centers all over the world. So many centers represented in this panel alone. And the upside to this is together we have that synergy to promote mediation as an option for end users and business users. But the downside is there could potentially be a lot of confusion in terms of alignment of standards, in terms of expectations of mediation performance. I know this was ably represented by Daniel in his presentation as to some of the inconsistencies that end users might face. That's why you have the UDPM. But there is a proliferation of these centers, and that is when we suddenly realized there was a need for some form of alignment, some form of standardization, some form of collaboration between the standards to help us and to also help the end users make use of it. So this is where the story begins. During the height of the pandemic, in 2020, when we were all locked down in our respective homes, dressed in our pajamas in front of everybody, 5 centers came together and we had many Zoom discussions. And these centers were the Asia Mediation Center, ICFML, which is the organizer for this event, IDRMI, which is a center based in Hong Kong and China, IFCM, which is based in France, and of course, SIMI, the Singapore International Mediation Institute, which is based in Singapore. So 5 centers came together, and we had this idea. Is there a potential for us to increase collaboration and to create a greater alignment in terms of standards, in terms of our credentialing, in terms of our experiences, in terms of our knowledge sharing, in terms of cross-border mediation and co-mediation? Is there a potential for working together then? And this is where the story gets interesting, because over time, these centers sat down. We compared all of our training and credentialing standards. We looked for opportunities to find alignment. And then when we came to some form of alignment, so that on the 28th of April 2021, it took us, I think, over a year to come to these kinds of agreements. In April of 2021, these 5 centers signed an MOU and a memorandum of understanding to have a cross recognition of standards. And this alliance, this MOU was called the Alliance Memorandum of Understanding on Alliance Standards. And so this MOU saw all of these 5 centers representing all these countries come together to commit to a collaborative instrument to promote greater cooperation between member dispute resolution centers, as well as to increase opportunities for co-mediation between mediators in the Alliance member centers. And inside this memorandum of understanding, we had a cross-recognition scheme, which effectively recognizes the standards for each of these centers, so that mediators accredited in each of these centers can seek empanelment in their partner center for the purpose of providing enhanced options for business users. And the greatest beneficiaries of this Alliance MOU were business users who were seeking a more cost and time-efficient way to resolve disputes which may occur outside of their jurisdiction. So we're talking cross-border disputes. Mediation provides an effective alternative to costly litigation or arbitration. We know this already. And it removes the uncertainty and stress of being in a foreign court. So the Alliance MOU represents another step in the evolution of dispute resolution as it combines the innovation of technology, because we envision the use of Zoom and other similar platforms to do co-mediation, with the existing financial accessibility of mediation to remove all barriers towards cross-border dispute resolution. And with the rise of regional free trade agreements promoting the lowering of barriers in trade, such as the Regional Comprehensive Economic Partnership, which accounts for more than 30% of global GDP, there is an urgent need to find borderless solutions to disputes arising from cross-border transactions. So above all this, the Alliance MOU recognizes the spirit of collaboration and friendship already present in these countries and continues the trend while maintaining global standards in the sphere of mediation. Now, are there problems? Are there pitfalls and challenges? Yes, there are. We try to meet every 2 to 3 months to discuss our evolving identity and function. What is our, are there to be new partners added? We are actively looking for new partners, new centers, new countries, new territories. And then we are looking for ways to define our identity, to promote mediation as a whole, and to promote and refine the standards that we have. So because within each center, sometimes there are changes to your accreditation process and things like that. But every time this happens, we try to find alignment in that. And so this is a little bit of the story is a little bit of a look from the field of how centers from different countries can benefit from entering into an alliance in order to standardize to the degree possible the kind of credentialing system there is, and to promote collaboration and knowledge sharing. So this is a little look from the field, from the alliance, and I welcome any questions that you may have on this one. Thank you. Over to you, Liana.
Thank you so much, Josephine. And it's so important listening to you, and more it becomes clear the search for quality standards and the certification work that we know that IMI and the ICFML, the qualifying assessment program, how is important, and the search for this environment of quality standards, the training, the programs. We are listening all of this during this event related to these centers spread all over the world. But how about the ad hoc mediation? We cannot forget the private, we used to say in Portuguese, the Latin word ad hoc mediation, those kind of mediation that is not under any center. Will these mediators spread, these individual ones, will they have these concerns we've been discussing here for quality, for standards, for all this search for this MOU and trainings and alliance for the UDPM protocol? I keep asking myself, because here we listen the center's concerns, and how about these ones we will not know? So this is just personal reflections.
Yeah, so whatever instrument we choose, whatever vehicle we choose, my opinion is you're not going to find a perfect one. There is no perfect solution. And so our pursuit, I believe, is always to look for areas of synergies, areas where you can find similarities, areas of overlap, areas where we can work together to boost the quality and the standards in mediation. And it could be that for mediators not attached to a center, it might be harder for you to you would be like a doctor searching for a patient. Sometimes it might be it is actually harder for you. But our need for alignment and standards and for synergies, we are putting the end user, the business user, first in our heart. This is to create this kind of clarity and alignment and collaboration so that they are able to seek out and have a clearer idea what each centers represent and what you mean when you go to this particular center and you are empaneled here, how you can also be empaneled in IDRMI by filling in a certain form. We try to make it easy for both mediators as well as end users in this regard. So it is still a work in progress. In fact, we have a meeting tomorrow to work out we have our next meeting tomorrow to work out some of the kinks that we are finding. What are some of the problems? And we are going to workshop some of them. And hopefully, each time we do this, our concept gets more and more refined to the benefit of end users as well as mediators.
Thank you so much. So I thank all the panelists and thank you.
Thank you, Liana, and really many thanks to all the panelists for sharing this innovative best practice. And mainly, it's very, for me, very rewarding to see the enthusiasm of each one of us on all these things that we share here today on the different institutions that you manage. Thank you very much, and I believe that the insights that you shared have certainly enriched our understanding of how mediation can be effectively applied across different contexts and different regions. As we approach the conclusion of this event, it's time to reflect on the key takeaways from our discussions today. This is not an easy task. We are here for more than 5 hours now, and given the depths and breadth of the topics we covered too, from the institutionalization of mediation in the legal system to the legal frameworks, finally the best practice shaping the future of mediation. To help us navigate this important summary, we are fortunate really to have Mariana Soares-David with us. Mariana is not only an exceptional legal professional, but also someone with a profound understanding of the mediation and its role in dispute resolution. Her experience and analytical skills will, I would say, without any doubt, provide us with an insightful and comprehensive summaries of today's discussion. Mariana, I know you have the challenging job of distilling today's rich dialogues into some key points, but I am confident that you will experience and your key insights, you will leave us with a truly exceptional final reflection. I already went to my WhatsApp group in Brazil saying, come for the last 15 minutes because Mariana will do this summary. And we had several people that entered the meeting now to listen to you. So the floor is yours, Mariana, and
thank you, Anna.
Listen.
Thank you, Anna. No pressure. So good morning, good afternoon, and good evening to all as applicable. I'll start, as many of us did, by starting to thank to ICFML, in particular to you, Anna, for the invitation to participate in this session. So summarizing the last hours of knowledge and experience, it is not only difficult, it seems rather unfair for each speaker, but as a mediator myself, I'll try to adapt to the challenge. I'll start with the title of this year's Singapore Convention Week, which refers to the need to separate disruptions from distractions in the evolving world. As announced by the Minister of Home Affairs and for Law in Singapore, and I'm kind of quoting, the main goal of this convention was to reflect on the differences between disruptions that can drive technological development and distractions that usually slow us down and cause regress rather than progress. So when I was reading these words, although I know that the convention had a much broader scope, I could only think that this would also be a good definition for mediation. Because mediation shows us that to the extent that the parties do not focus solely on the problem and on the distractions it brings, this would be emotions, costs, litigations, etc., every problem causes a disruption between the parties, that's for sure. But it is also an opportunity to revisit the initial terms of the relationship, to rebalance things if it's needed, to set some boundaries. So in the words that were actually used in the ICFML video we saw at the beginning, this comes down to turning conflicts into opportunities. And well, sorry, because I got messed with these notes. Oh, sorry for this. Just shifting the view, sorry for that. Okay, this will work. Sorry for using notes, but this is too much information. So because I actually do believe this, this comparison between distractions and disruptions, one of the things I really like about the initial paragraphs of the Singapore Convention, Mediation Convention, is that the UNCITRAL therein states that mediation, especially upon a uniform legal framework on international settlement agreements, can contribute to the development of harmonious international economic relations. It was not simply an investment of the UNCITRAL in one particular ADR method. It was UNCITRAL acknowledging the relevance of mediation for international business, and this for me is kind of key. Today's final session, East meets West, was targeted specifically at mediation and intended to promote a dialogue between geographical realities in which mediation is evolving as we've seen in very different speeds: Singapore, Macau, Brazil, Portugal, and Africa. I will not try to be exhaustive, as I could not be, but briefly put, in panel 1, we focused on the integration of mediation within the court systems and other government-managed frameworks. When looking at Singapore, we see that the 19s marked the beginning of commercial and family mediation in Singapore, and so much has evolved. Regarding commercial mediation, I would highlight that it started as a court-annexed mediation and evolved to a true ecosystem, putting together courts and practitioners, training and certification institutions, such as the SIME, and several mediation institutions, some of them very specialized in specific disputes. Also, it benefits from a very supportive court system and legislation, and this resulted in very inspiring statistics from 67% to 80%, well, with the good experience of the Singapore Mediation Center being able to reach agreements in 90% of them reached an agreement in one day. Regarding family matters, Singapore soon understood that mediation would be a more appropriate dispute resolution method for these specific matters. So this resulted in a separate family justice court, where the rates are also around 60%, the rates of success, and which has now evolved to a form of therapeutic justice, with the participation of a specialized judge mediator and multidisciplinary teams, including family specialists and even training doctors. Regarding Portugal, the starting point was a decade later, much due to the creation of a public mediation system by the Directorate General for Justice Policy of Portugal. It started with the creation of peace justice, as we've seen, providing for smaller cases mediation services, either within an ongoing civil proceedings, either as a separate services. But only 30% of the cases used mediation, and the rate of success is a bit lower, rounding 35%. Then followed 3 public specialized mediation systems where courts can refer to mediation, with many certified mediators and with limited costs or even no costs. This would be family, labor, and criminal mediation systems, but only the family mediation system seems to have relatively good experience, although it is still very limited also, because only 50% of the cases end up in mediation, and the rate of success is around 40%. In fact, as it was pointed out, and this comes from my personal experience, Portugal seems to have a significant gap between the legal system, which is already kind of favorable to amicable solutions, and the actual reality. Several reasons could be and were pointed out for this gap: lack of awareness by legal practitioners, notably judges, which may be a cause for limited referral to mediation, or even reluctance of lawyers. Therefore, a strong and broad campaign of promotion of mediation, including to its companies and citizens, is needed and seems to be in the agenda of the Directorate General for Justice Policy of Portugal. Looking at Brazil, the starting of mediation in Brazil is closer to the one in Singapore, and I was kind of happy because perhaps that is the reason why Portugal is still a bit behind. The curious thing about Brazil for me was that it started in small cases court created by judges themselves, and only subsequently was it formalized by law. So it did not derive from a legal choice. Mediation is nowadays a very successful ADR system in Brazil, and notably for the following causes: the creation of judicial centers for dispute resolution close to judicial courts, training of judicial mediators to work jointly with judges, a favorable mediation law, many legal incentives to the recourse of mediation, and all this resulting by now in many savings and a reduction of around 30% of the cases in certain courts, so decreasing the pendencies in judicial courts. Moving to panel 2, there we explored legal frameworks governing mediation. Much was discussed, but looking at the main points, regarding incentives in each jurisdiction, mediation is voluntary in all countries, with some different incentives in each country, be them legal, so the incentives could be legal in some cases, turning mediation mandatory for some areas, financial, as a potential sanction if voluntary methods are not used, which could be good if this was applied, but from my personal experience, this is not applied in Portugal, and Katia also explained this, or incentives can be based on court encouragement. Nonetheless, it is clear that for now, common law countries have stronger incentives implemented. Professionalization of mediation. So the landscape here is very different, and a mediation career is not legally set up in all jurisdictions, especially in Angola, Mozambique, and Macau. Regarding the enforcement of agreements, confirmation by court in mediation within court procedures is common to all jurisdictions, and all of them also have direct enforcement agreements, so that they all provide for direct enforcement of agreements that are obtained outside of the courts, dependent on certain requirements, and these requirements can vary from jurisdiction to jurisdiction. In Portugal and Singapore, the relevant note I would say is that the requirements are linking enforcement and professionalization. So this was really curious to see. And in the end, well, Brazil has also some specific areas in which confirmation by the court is also always required, well, depending on and because of the specific areas it relates to. And finally, mediation rulings. Only Singapore and Brazil signed the Singapore Mediation Convention, and all international mediation laws are quite soft, ruling mostly broad principles, such voluntary confidentiality and enforcement, and not quality, although Portugal at least also broadly rules on the procedure. Finally, panel 3, which was focused on best practices to promote mediation in Singapore, Brazil, and Portugal. Regarding Portugal, we spoke about 2 arbitration and mediation centers: Arbitrare, targeted at IP conflicts, and Commercial Arbitration Center of the Portuguese Chamber of Commerce and Industry, which targets at commercial disputes. In Arbitrare, mediation is offered before the arbitral tribunal is constituted. However, statistics show that arbitration has not been a precursor to mediation, despite several incentives, notably lower costs, online platforms, and a faster resolution. However, they recently started offering mediation out of the context of arbitration, with the expectation that it can be a precursor to arbitration. So mediation could be a precursor to arbitration, but until now, no requests for mediation were filed. The Commercial Arbitration Center is a very reputed arbitration center that in 2011 started giving some attention to mediation. In 2016, they approved the first mediation rules, and more recently, they created a specific mediation committee targeted at the promotion of mediation through the center. And some of the most recent relevant initiatives are the inclusion of a mediation panel at the annual Centers Conference to share successful stories about mediation, the organization of a new certification court course for private mediators, which ended up being a success and included lawyers from the most renowned law firms in Portugal, and a temporary offer for an initial session for mediation for arbitrations ongoing on the center, which at the time had no requests, but that may be worthwhile recovering after this certification course. Brazil talks to us about the Brazilian Federal Court of Accounts that now contains a group of auditors acting as mediators that form part of a committee to find a proposal solution in 90 days to be approved by the federal court, all for the benefit of public interest. A method that shows that mediation in public matters is not only possible as it is desirable. Regarding Singapore, it was shown that Singapore has numerous specialized mediation centers, and this was really inspiring. One of them is FIDREC, which focuses on conflicts between consumers and financial institutions, trying to balance the power between the parties using specific techniques and abiding by SIMI rules. And on a more high-level approach, we discussed the Universal Disclosure Protocol for Mediation, created to promote a set of rules or topics to be addressed right at the beginning of the mediation to make sure that all parties and mediators know exactly what they're up to, as a way to increase self-determination from the start and make sure that no expectations are violated. And finally, we heard about an inspiring story of the alignment between 5 mediation centers in 2020, starting in 2020, including the Asian Mediation Center, based in Malaysia, the ICFML and the SIMI, to promote mediation as a whole, create global standards and a cross-recognition scheme. So moving to closing, and I think I'm still on time, I would like to highlight 3 main ideas. The first idea is that Singapore has made a significant and successful investment to become a relevant mediation and dispute resolution center hub, as we heard in the welcome message. And this event was just another demonstration of that. The second idea is that in addition to all the relevant information that was shared throughout the sessions, these 3 panels brought us all, I think, above all, perspective. And again, one of the things that mediation teaches us all is that perspective is crucial. Even to know if we are on the east or west side of the world, we need perspective. Perspective is crucial to understand the others and ourselves. It is crucial to maintain and repair commercial relationships and also to evolve in any area, including in the promotion of mediation. And the third and final idea is hope, that Anna also mentioned at some point. The fact that we could gather today such a relevant group of speakers to hear each other's examples and experiences in mediation should bring us all hope, especially to those of us from Portuguese-speaking countries, as myself, that often get frustrated thinking why mediation is not yet a success in our home countries. May this perspective we now gain inspire each other and our authorities in seeking better ways to promote and invest in mediation, and consequently, as the Mediation Convention says, to contribute to the development of an harmonious economic relations. So thank you.
I knew it. I knew it that you could have done it so in such, I don't know, you know, this excellent way. You were here live during this time, and here we are. You know, thank you, Mariana, for this amazing summary of this conference, and thank you for being here with us and for always answering yes when we ask you to come to our events. And I really believe that lawyers, at least in Portuguese-speaking countries and this, I believe that lawyers that are very known in the Portuguese setting and that can come to a message about mediation, like Mariana, like Filipa, like Joana, and I'm speaking in Portugal because otherwise if I go to Brazil, of course, I talk about Liana, I talk about Renata, I talk about Monica, I talk about so many other lawyers that really are seen as high professional in the law scenario, and that now are speaking about mediation. That gives us hope. Yes, it's hope. Thank you, Mariana. And we arrived to the end of this, for me, inspiring event. I would like to extend, first of all, my deepest gratitude to Maria Pardal Monteiro and Julia Albuquerque, that without their dedication and hard work, this would not have been possible. Hi, Julia. Welcome and thank you very much for your work and for helping me and us to put all this together in the last months. I want to leave you with a message that embodies the spirit of ICFML. Our slogan is, together we make a difference, together we transform. And I always say this is not only a slogan, it's what I say, a call to action. Each of us, I believe, has a role to play in shaping the future where conflicts are not just resolved, but transformed into opportunities for growth, for understanding, and for collaboration. I believe on that. And so by working together, we will build a legacy of peace and justice that I hope will endure for generations. So just say, let us continue this journey with shared commitments to making our world a better place. One mediation, one conversation, and one partnership at the time. Thank you for being part of this transformative journey. And together we will continue to innovate, to inspire, and to create lasting change. With this event is now closed. Thank you to all for being here and contributing for its success. Thank you.